Lord, despite there being a order for representation, they have not taken the complainant seriously, Lord. Kindly post this matter.
Can it not wait after vacation?
Okay. Maybe taken on record. The memo might be taken on record, please.
Take it. Put it after.
Contempt petition. It's regarding a child custody matter, wherein there is a specific order by this court to get the child admitted to the school, and still the respondents have not complied with the order. So that may be posted because the child is already 9 years old. Till date, he is not admitted to any school by the grandparents. The child is with the grandparents. That may be posted on Monday.
But now it's a vacation.
No, otherwise he will lose this academic year also because it's already 9 years.
Which is the last date for admission? Which school? Which is last date?
Last date it was I can school, which with last time your lordship might recall that there was a specific order from this honorable court in this contempt petition only, because the respondents were alleging that the child is psychologically having some psychological problem, where the team of experts have come back and reported that the child is not having any problem.
It's from Mysore.
Yes, Srirangapatna.
The parents went to Dubai, etc.
Yes.
That's the case.
Yes.
We'll post it on Monday.
Yes.
It is there.
It is there. Madam, if date is already given, then we will not prepone it. In your matter.
Even for compliance in June. That is the reason, because that there's.
Court has given some date.
My lord, we have yesterday the matter was posted before the lower court, and we have came to know
This
court has given any date.
Date for yes, for compliance.
This court has given any date.
Yes, my lord.
Date is given.
21st June.
Then file IA for preponement.
Yes, my lord. I'll file it. Yes.
Lord, blacklisting has been stayed by this honorable court, despite which, my lord, the employer is rejecting my bids, my lord. I filed a contempt against the violation of the interim order, my lord.
Hold it Monday.
My lord, this is a public interest litigation matter. Karnataka Medical Council, registered under Karnataka Registration Act 1961, also sits as a quasi-judicial body. Illegally from 2023, November, they are sitting illegally, not having the power to adjudicate the matter. Kindly may be taken up on Monday, my lord.
Sorry, refused after vacation.
A public interest litigation filed by the villagers seeking the shifting of the solid waste management unit.
After vacation.
It is in between the village, it is proposed to be located.
Right.
We have filed one more public interest litigation, my lord. This is with respect to the Samadhi of iconic film actor Vishnuvardhan. The fan club have filed the PAL seeking for consideration of their representations. That may be posted by.
One more refusal. Refused.
Yes.
Lordship, this is a contempt matter, fresh petition. FIR was stayed by this honorable court. However, despite communication, they have filed charge sheet, my lords. It may be had on Monday. It's only because of the apprehension of their high-handedness.
Let it come in due course. Yes.
Grateful.
Serial number 40, my lords. This bench would be disabled. Serial number 40, my lords.
I am disabled. I am the order.
Please, please.
Yes.
My serial number 49, my lord. Yeah, I have to pay the process. I'm paying no, my lord. 49.
My lord, there are two writ appeals which we have preferred as against the writ petition disposed in this honorable court. wherein that it was the appellant's case was disposed because of delay in latches. So without looking into merits of the case, why they have not filed the writ petition after after certain years of delay, the Honorable Court has disposed the case. The case has to come for the admission, kindly posted on Wednesday, my lord.
What is the urgency?
My lord, if at all it is admitted, we can send the notice by vacation. That's
After that.
My lord, serial number 35, your lordship. Serial number 35.
On submission, your lordship.
Seek an adjournment.
Lordship, serial number 13, we are for the petitioner, your lordship. There's a mat.
Serial number 18, your lordship, on submission. Serial number 18, Somshekhar is not well. Kindly after vacation, your lordship.
What do you want, 13?
Lordship, an adjournment by 2 weeks, your lordship.
Granted. After vacation.
Obliged,
Number
Your Lordship.
34, my lord.
1-3.
Preparing for the respondent. I request for a short adjournment.
After.
I appear for the appellant in the matter. The
After.
interim order has to be extended.
It will be extended.
On submission, serial number 18, your lordship, Somshekhar is not well. Kindly after vacation, your lordship.
Writ petition fresh matter, my lord. Writ petition fresh matter, my lord. The respondents are using excessive explosives to the blast in the query of operation, my lord, due to which for blasting of the stones, my lord. Within the radius of the 500 meter, my lord, there is a school as well as 25 houses located, and also there is a temple, my lord, which is causing a lot of inconvenience to the localites. My lord, there is an urgency to hear this matter. Kindly list it on Monday, my lord.
It's PIL.
PIL, my lord.
After that. After vacation.
There is an
On submission. Submission is serial number 18, your lordship.
After vacation. Yes, Mr.
Serial number 18, Somshekhar is not well. Kindly after vacation, your lordship.
18.
18, your lordship.
So what is the request?
For the appeal for appellant, your lordship. KM Somshekhar is not well.
Not well.
Yes, your lordship.
After vacation.
Get floor.
Serial number 1. Lomesh.
Hand over the objection in the region.
Filing our rejoined,
yes,
because that is also ready because they have to get the signature.
Yes.
My lord, sorry. My lord, sorry. In this case, my lord, the learned, my lord, when we filed the appeal, we didn't have the benefit of the order. Thereafter, my lord, after 5 days, my lord, my lord, the judgment was put on the website, and then we got it. 2 facts, my lord, the learned single judge has held against us.
Where is that order?
My lord, we have filed it along with an amendment application, my lord.
IA4 of 24.
IA4 of 2024. With 40. page 855. My lords get the 855, my lord. It starts. Can I request your lords to turn to my lord paragraph 7 at 862? Learned senior, sorry. 862, my lord, para 7. Learned senior counsel for the petitioner would join issue to contend. Petitioner does not have eligibility to submit the bid today. It will get eligibility if time is granted as the magnitude of the project is too huge. This was not a statement made. We filed a review petition. It came up day before yesterday. Since, my lord, the appeal was before your lordships, Learned Senior Judge said, my lord, directed to be listed after vacation. This is the first ground, my lord, on which, my lord, we have been non-suited. I am not, my lord, I appeared. I did not make this statement. Second contention, my lord, was, second submit, my lord, the ground on which, my lord, I have been non-suited is that, my lord, I did not submit my bid. Therefore, my lord, I am not entitled, my lord, maintain a writ petition. We have challenged. These are the two grounds on which, my lord, I have been non-suited. Second is, my lord, that we did not submit our bid.
You did not
Submit my bid.
So you never participated.
Therefore, my lord, I am ineligible. My submission is we challenge, my lord, the very time stipulation given, my lord, in the tender, saying that it is too short. In fact, my lord, there was a pre-bid meeting. All bidders, without exception, said, my lord, this is time given is too short because it's an 8,000 crore, my lord, project. It, my lord, required, my lord, the study of the terrain because this has to be, my lord, in the Western Ghat. There has to be a tunnel. Entire civil engineering is, my lord, below the surface. Therefore, my lord, for submitting, my lord, a bid, one has to study the terrain. They, my lord, there were about 270, my lord, queries.
Construction of road.
No, my lord, construction of a hydroelectric project, my lord. My lord, I had given, my lord, one list of dates and doesn't matter. This is an 8,000 crore, my lord, project. This was envisaged, my lord, 10 years back. Serial number 3, my lord, in the list of dates and synopsis. Estimated cost is, my lord, 8,505 crores. Period of the contract is 5 years from the date of handing over the site. Last date of submission, my lord, is 9/2. Date of the meeting, my lord, on 14/2. Submission was 21/2. More important is clearance, my lord, environment clearance and, my lord, wildlife clearance and, my lord, the none of which have come. They are yet to, my lord, apply. Can I seek your lord's indulgence to just turn to, my lord, volume 1, page 134.
Notice inviting tender was issued 9th January.
No, my lord. After 9th.
9th January.
2nd of February, my lord.
2nd February.
Serial number 2, my lord, of my list.
Your petition says 9th January.
9th January.
9th January, my lord, was a draft.
Draft. Okay.
Final, my lord, was
2nd
this.
February.
2nd of
is,
February.
Draft.
Yes.
And 2nd of February.
February, my lord, is the.
Final.
Yes, ma'am.
Inviting tender.
Yes, ma'am.
Then some corrigendum was issued.
My lord, 2 days, my lord, it was extended from 21st to 23rd.
What was the last date of submitting the bid?
23rd.
23rd of
February.
When did you file this petition?
WP
20th
was
of
filed
February.
on.
20th of February.
20th of.
Corrigendum came on 17th.
Corrigendum came on 7th.
Yes.
Extending it up to 23rd.
23rd.
17/2.
And clarifications, my lord, there were 270, my lord, queries by all the bidders. That clarification, my lord, was given by them not fully but partially on 17/2. They, my lord, gave what is known as a geotechnical report. Please turn to, my lord, paragraph 8 of my list of dates. Tunneling, my lord, is the most important aspect of this, because, my lord, this is hydroelectric project, my lord. Water has to come from the reservoir, and then, my lord, it has to, my lord, garner the generator. So, my lord, the geotechnical, my lord, report that they gave, tunneling, my lord, there's nothing has been done. They say, my lord, that it was inaccessible. Therefore, my lord, the report, my lord, is silent. It says, my lord, that we have not been able to do it. So, my lord, people will have to, my lord, the bidders will have to study that and then, my lord, submit their bids. This was submitted, given to us on 17/2. And if your lordships look at, my lord, serial number 8, if your lordships turn to, my lord, page 670, 641, my lord, is that study. It specifically says tail race tunnel, the main, my lord, access tunnel, the cable access tunnel, my lord, they have not studied it. That is, my lord, the geotechnical service, report, my lord, is for that only. And they say, my lord, it was inaccessible because, my lord, there are trees, my lord, that requires, my lord, the cutting of trees or whatever it is. And more important is, can I request your lords to look at, my lord, the very NIT, my lord, for a minute. Please come to, my lord, volume 1.
So what is the challenge?
Two things, my lord, I am before your lordships. One, the time given, my lord, was too short.
Time for submitting bid.
Yes, my lord. Secondly, my lord, that the under, my lord, Rule 17 of the Karnataka, my lord, Transparency, my lord, in Public Procurement Act, 30 days is the minimum periods prescribed. Unless, my lord, if they want to shorten it, my lord, there must be a reason given.
But it appears two judges of this court have held it to be not mandatory.
No, my lord. They have held, my lord, that it is mandatory. Can I give your lordships, my lord, some judgment for my lord's consideration? They have held it is mandatory, but what they have held is the reason, my lord, ascribed. If, my lord, the note sheet, my lord, provides for it, it is more than sufficient. That's what it is. But, my lord, here, my submission to your lordships is, sorry.
Rule KTTP.
Page 80.
Yeah. Minimum, my lord, time for submission of tenders. Sorry. The tender inviting authority shall ensure that adequate time is provided for submission of the tender. Minimum time is allowed from the time of publishing in the Karnataka Public Procurement Portal and the last date of submission of the tenders. This minimum period shall not be less than the period mentioned below. Tenders up to 2 crores, 15 days. Tenders, my lord, in excess of rupees 2 crores, 30 days. Any reduction in the time stipulated under sub-rule 1 has to be specifically authorized by the authority superior to the tender inviting authority for reasons to be recorded in writing. This reduction of time, reduced time, shall not be less than 7 days.
Here reduction will be less than, no.
No, my lord. What has happened is, it is about 21 days. They say that, my lord, it was a board meeting. Board meeting, no reasons are given. Then, my lord, the managing director, my lord, says, my lord, I have given the reasons. That is an insertion. According to us, my lord, we have placed also that matter, my lord, is not considered by the learned single judge.
But 17(3).
Yes, my lord.
Mentions what is mandatory.
Yes.
And into that, 1 and 2 do not fit.
Last date for submission of tender so fixed. Sorry, my lord, my apologies.
This question we are putting
Yes.
because of that exclusio ulterius maxim, which Maxwell discusses, Broom's legal maxims discusses,
Yes.
where that perhaps you are aware of that. Maxwell is on particular page there. Take it. What is intended to be mandatory is specified by the lawmaker. That is only a circumstance that is couched in a language, mandatory language, because it uses the word mandatorily under sub-rule 3.
Last date for submission of tender so fixed shall be on the working day and shall be mandatorily between 10 hours and 17:30 hours.
Therefore, a situation that does not fit into 3 is spoken of by 1 and 2. Just see Maxwell.
My lord, can I seek your lord's indulgence to again look at?
So my brother says that by very virtue of the language of subsection 3.
Yes, my lord, can I?
Other parts becomes non-mandatory.
Can I seek your lord's indulgence again have a look at subsection, sub-rule 3?
That is how we construe the provision.
That's how
Sub-rule,
Maxwell says.
my lord, mandatory is with regard to the hours, 10 hours
Correct.
and 17:30 hours.
Subsection 3, you could have argued that 1 and 2.
2 are also mandatory.
My lord, can I,
And legislature said this is mandatory.
can I, my lord, of course, that may pale into insignificance because before the learned single judge, my lord, they said, no, I can submit my bid. Therefore, my lord, that may not, my lord, that may pale into insignificance. That contention of mine.
30 days. In other words, we have given them 30 days, 32 days. Because
When the
during
matter came up before the single judge,
Matter came up before single judge, we said, you to submit your tender, even now, we have no objection. They refused to submit the tender.
Yes,
it's
my lord,
recorded
that's what I'm saying.
26 March 2023. Yes, recorded by the single judge. On 26 March 2023, we permitted the petitioner to participate in the tender.
That's what I'm myself saying, my lord. Therefore, I said it pales into insignificance.
7, my lord, of the internal page 7 of the impugned order. My lord's got page 7, my lords, of the judgment. Last 3 lines, my lords. Last 4 lines, you would contain that as on day when the matter was being heard on 4th March 2023, the time is beyond 30 days. The corporation has not yet opened the technical bid. Even today, if the petitioner submits the bid, the corporation is ready to accept. The Advocate General would thus seek dismissal of the petition. My lords, he refuses, petitioner refuses to participate in the tender, saying that I want time till 3rd of May. His specific prayer is, grant me time till 3rd of May to submit my tender. That is his prayer. The question is, my lord, whether the tenderer can fix a date when he is going to submit the.
My lord, let me point out. My lord, let me, my lord, dilate on that. Please
sorry,
take.
I'm sorry.
Doesn't matter, no problem. No problem. No, you are definitely entitled to. Please take, sorry. Even without heat being generated, my lord, the alarm is on. There was no heat at all between us. Can I seek your lordship's indulgence? Look at paragraph, my lord, page 115. Look at the tender. I'll tell your lordship's why.
Expressio unius exclusio alterius.
Take out from this. There is such, I have read that. It is there.
Yes, it is there, my lord.
Ulterius,
Expressio unius exclusio alterius.
Same thing, page 293.
293.
Just the
Expressio, yes.
My lord, please come to my lord.
Expressio unius it is. Expressio unius exclusio alterius.
By the rule usually known in the form.
Anyway, we'll just.
I'm sorry.
That's why, my lord, I submitted. That pales into insignificance by the fact that, my lord, they gave me, my lord, 30 days time. Therefore, I submitted that, my lord, it pales into insignificance. But
No, you are right. You are only
a bidder.
Offerer.
Correct.
You are an offerer.
Correct.
So
Correct.
invitation is what? Tender is what? Invitation to.
Yes, my lord.
So what is your right?
I'll tell you,
to
lord.
Tell the offerer.
I'll
No,
tell
no,
you.
you should do the things this way only.
I'll tell you.
Unless you fit into legal.
I'll tell you,
framework.
Lordship. I'll tell you, Lordship.
Your friend comes to your house
Yes.
and gives an invitation
To do
to come
certain
to the
things.
marriage of his son. The marriage is on a particular day. It is not convenient to you, don't go.
My lord, can I submit? My lord, what your lordships are saying, absolutely right, but then, my lord, the fact situation here is
Simple
different.
matter, very simple.
Please come to, my lord, page 100 and
Inviting you to come to their marriage. You don't find the date convenient, don't go. Who compels?
please come to, my lord, 115. Look at the tender.
You want to change?
The third one is Cheshire Fifoot and Firmston. It's considered to be one of the best books on
Yes.
law of contract by House of Lords.
Correct.
They discuss this aspect. Unless you show that you have right, as my lord has now pointed.
Yes.
We are inviting. It's an invitation to
Agreed.
offer.
Agreed.
Nothing beyond that.
Agreed.
What is your right to say? No. You should prescribe this period only.
Let me,
When
my lord-
others are happy with that, others have participated.
1 minute. Let me, my lord, give your lordships, my lord, a sequence of events. Bids were invited on 9/2. I'm sorry, 2/2. My list of dates, my lord, has all that. Two was the tender, indisputably. They called a meeting of the prospective bidders on 9/2.
Meeting was on 9/2.
14/2, I believe.
14/2.
Yeah. There's some small mistake, my lord, in page, first page. I'm sorry.
Right.
17/2, my lord, they give partially clarifications.
17/2 is corrigendum.
My lord, 17/2, they give, my lord,
Both corrigendum and
they give the clarification, my lord, of part of it, not the whole of it. And, my lord, the corrigendum. They also give the techno-economical, my lord, geotechnical report, which is, my lord, specifically says, my lord, that it is incomplete, which does not, my lord, cater to the requirement at all. More important is they were, my lord, trying to, my lord, beat the code of conduct. That is our case also. We have stated that. What happened is, please come to, my lord, in this background, please come to, my lord, page 172 of the tender. Page 172, sorry, 134. 115, my lord, of amendment has, my lord, first volume, my lord, first volume has the tender. Please come to, my lord, page 134. Para E.
environmental clearance.
Please, my lord.
Environmental
Correct,
clearance.
correct. Environment clearance, EC. Wildlife clearance are under process and being submitted. They have not even submitted it. And being submitted to the concerned authority, the Forest, MOEF and CC for approval. Any modification suggested while according to the EC and WC are deemed to be included in the scope of the work of the contract. My lord, if the EC says, you will have to do, my lord, so many things, The entire, my lord, financials will change. How am I to give it? Not only that, please come to, my lord, page 100 and, my lord, 73. Page 173. Sorry, 175. I'll, my lord, I'll read, my lord, go back a little. 175, if your lordship sees. (1.41). In that, my lord, third unnumbered paragraph. Obtaining of approvals of MOEF, EC. That is, my lord, the Ministry of Environment, Environment Clearance, Forest Clearance,
Are in process.
and WC are in process. In case approval from the concerned authorities are delayed, letter of intent shall be issued after the receipt of the approval. Correct. So, my lord, they have not even applied for the approval. Approval, my lord, after it comes, my lord, then please come to bottom, my lord, 1.43.
No, they had applied for,
They had
but
not
they were
applied.
being processed.
No, they have not yet applied. Please come to, my lord, again, 134. Please come to 134. Please have a look at it. Being submitted. And it's a specific case, they did not submit. It's not denied. 134E, page 134, last paragraph, being submitted.
Correct. They are putting you, it's a caveat emptor.
No, my lord, I'm
They
not.
are saying,
Huh.
question is,
Huh.
we are going to do A, B, C, D.
Correct.
How can that be, that give rise to a right in your favor?
I'll tell your lordships. Would your lordships again, my lord, look at E for a minute. Look at the last sentence. Any modification suggested while according to EC and that is Environment Clearance and WC are deemed to be included in the scope of the work of the contract. If, my lord, the EC and, my lord, WC, my lord, says that, you'll have to do, my lord, tunneling, my lord, has to be increased by about another 50 meters. Entire costing will change. Not only that, please come to, my lord, page 175 now. 175, 1.43, bottom. If, my lord, the letter of intent, my lords get that.
One point?
175. My lords got that 175, my lord?
Yes.
1.41, if your lords is first have a look at it. Third, third unnumbered paragraph in 1.41. Obtain.
E and this
Yes.
are the same.
Correct. No, are in the process. Obtaining of approvals are in the process. In case the approval of the concerned authority is delayed, letter of intent itself, my lord, will be issued after the receipt of approval. Not only that, please come down, my lord, 1.43, bottom. Letter of intent shall be effective on fulfilling the following: handing over encumbrance-free site, access to site, and, my lord, environment clearance. All these are yet to come. It takes, my lord, 6 months. Even, my lord, I will point out all that. They themselves say somewhere in their objections. And
Then what turns upon that?
my lord, I'll tell your lordships. Unless, my lord, sufficient, my lord, time is given for us to study.
Something might turn up. But does it create any right in it?
Yes, my lord, I'll point out. Can I, my lord, in this at this juncture, seek your lord's indulgence to look at, my lord, there, my lord, everybody said, my lord, every bidder said, my lord, extend the time because this is not sufficient. There are, my lord, two things. One is, my lord, a civil contractor. Another is, my lord, the electrical and mechanical contractor. They'll have to, my lord, form one consortium or joint venture and then, my lord, submit the bid. Everyone, without exception, civil contractors as well as, my lord, the electromechanical contractor said time given is insufficient, therefore extend it. It was not extended. Question is, my lord, as your lordship rightly pointed out, Honorable Chief Justice, does it create any right? My lord, my submission to your lordships is, yes, please take, my lord, one judgment for my lord's consideration.
We'll also ask them when the turn comes, but we are asking right now.
No, my lord. My lord, asking, my lord, clearance of doubt is our duty. Your lordships, my lord, have a right to ask. If your lordships don't ask, we will not be able to clarify it, my lord. I always invite it. And that's the right approach, my lord, according to me. Of course, some judges, my lord, don't speak at all. But then, my lord, I would always invite this because every doubt must be cleared.
Did you participate in contracts of the kind earlier?
My lord, I have, the capacity.
What
to-
was the time given in those contexts?
Yes, please come to my lord. Running page 356 in the same volume. 356. Ours is, my lord, 2000 megawatts. Lord, 850 megawatts, first one. Rattle, my lord, HEP, Jammu Kashmir. Time, my lord, if your lordship sees, original, my lord, number of days given, last 102 days. NIT, my lord, was 22nd of July. Final submission, my lord, was 1st of November. 102 days. Second one, Kaiga, 155 days. Third, Sunni Dam, my lord, Himachal Pradesh, 254 days.
Whether these works are, they approximate to the nature of the works under the tender?
Correct.
In
correct,
question?
Correct.
No.
Yes.
To deny it?
No.
Anyway.
My lord,
Which,
all of them except Kaiga. Kaiga, my lord, is not a tunneling project, but all the others are tunneling projects. Rattle HEP, Jammu and Kashmir, my lord, is a tunnel. It's a underground this thing.
what is the length?
My lord,
Depth
850,
of the tunnel.
850 megawatts, my lord, ours is 2000 megawatts.
Projects are different.
That's
my
the
lords.
power. The length, tunneling length, it depends upon that, not on the capacity. What is the length?
My lord,
Because you spoke of drilling, etc. So that length you have to say, that's one of the factors.
Project itself is different. My lords.
my lord,
We
with the
want to know.
greatest respect,
We'll come to.
nowhere have they said these projects are different from, my lord, the one envisaged here.
We want to know.
The document itself.
Just we want to know,
Yes, my lord.
what is the length of the tunnel, intended tunnel on these
My lord, can I,
tenders?
in that event, can I request your lordship to have it at 2:30, my lord? I'll try and get and
No, I
place
wish
in
I
the
will
file.
go on, but in the meanwhile.
Very well, I'll give you a lordship.
We will go on.
I'll give you a lordship.
Meanwhile.
No difficulty. No difficulty.
Number one. Another
Yes.
question.
Yes, my lord.
There will be questions to you also, as my lord has said. But presently we are,
No, my lord.
our focus is like this, thereafter. if the
Absolutely.
order comes this side, you have some question to answer.
Oh, no. All this will not.
We are asking.
Because not asking of question or asking.
You can prepare yourselves. The other question is, who decides this period tender? Is it technical people or some non-technical people?
Strictly speaking, it has to be technical people.
It has to be?
Yes, my lord.
It
Otherwise,
appears to be. Have you taken up anywhere, have you taken up the contention? This period is prescribed by non-technical people who do not
we
understand
have not stated
ABC
that.
at
We
all.
have not stated that. We have not stated that.
But generally,
Yes.
there is one judgment of the apex court also. Generally, these are mega projects involving thousands of crores investment.
8,000 crores.
8,000 crores.
Largest in the country.
Maybe. Therefore, decisions of that nature will be taken by involving all experts in the many fields, concerned fields.
My lord, can I
It
put
is
it?
not that they do not understand, and we understand, or only your client will understand.
Can I put it?
Not that.
No. Can I put it in this manner? They should have, my lord, 103 of the Evidence Act. It is within their personal knowledge. They should have said that. Nothing, not one whisper. That's all I can say. More than that, my lord, I can't say anything more. My lord, my comprehension was that, my lord, yes, it has to be by technical people, not non-technical people. But there is nothing on record. Then, my lord, the time given is inadequate, is what, my lord, everybody, my lord, without exception stated. Can I request your lordships? Take, my lord, page 46. Sorry,
Only,
498.
Mr. Hulla, to put it metaphorically,
Yes, my lord.
we are conducting a race, running race.
Yes, my lord.
We are saying 100 meters, you have to run within particular period. If you are not capable of running, retire from the race. There are other people,
Correct.
other PT Ushas
Correct.
who will run.
Question
But how
is,
that will give
yeah,
right?
I'll tell you, lord.
And one of them is
I'll-
very much.
I'll tell you, lordships. the, without exception, at the time of, my lord, the pre-bid meeting, everybody said, my lord, the time is, my lord. That's why, can I persuade your lords, turn to, my lord, page 498, 498, volume 2, sorry. This is volume. Page 498.
Of volume 2.
My lord, the meeting requested for extension. Sorry, that's why I told you to.
Volume 3.
This is like
1
every
minute.
student aspiring. Let the examination be postponed. We'll prepare more.
My lord, that is one way of looking at it. If, my lord, the portions are not completed, and, my lord, if the examination is conducted, every student, my lord, saying, please postpone the election, my lord, the examination. 532, my lord. Not for 532. Everybody asked for it. Not that I say. Everybody asked for extension. My lord, please come to 525. 525. During 46, my lord, serial number 46. During the pre-bid meeting, all bidders requested for extension of time for tender submission. Revised time, therefore, my lord, they extended it, my lord, by 2 days.
This is an extension of period.
Yes, 2 days.
But in their wisdom.
21st to 23rd, last date for submission. My lord, I asked myself this question. If EC clearance, forest clearance, WC clearance have not come, they have not even applied, take 6 months.
It is applied, Manoj. I don't know why they're saying not applied, not applied. It will
The
be.
language gives that impression. Therefore, because you know that, as you say.
That's why I'm clarifying. I'm sorry, Manoj.
My lord, before the learned,
On which they were applied also.
learned single judge, before the learned single judge, this was not stated. Now, of course, they are saying that it is applied. When it is applied, my lord, is also not made clear to your lords. Anyway, they'll make it clear to your lords. Very well, very well, very well. The fact of the matter is, everybody, my lord, sought for extension, saying that, my lord, time given is too short. 2 days, my lord, for such a large, my lord, project of, my lord, it's the largest, my lord, hydroelectric project, my lord, in the entire country. 8,000 crores, 2,000, my lord, megawatts. Entire, my lord, civil construction is below the ground. There are tunnels. And, my lord, the time given, my lord, if it is too short, competition, my lord, gets reduced drastically. One. Secondly, they were trying to beat, my lord, the code of conduct and, my lord, award a tender. They had already, my lord, this is our contention also, my lord, we have stated that on oath.
Election code of conduct.
Yes.
How you are concerned with that?
After that, my lord, they can't, my lord, finalize the tender.
How you are concerned with that electoral code of conduct?
I'll tell you, lords, I am not concerned. They were, my lord, trying to do that. Therefore, my lord, short time was given, my lord, and then, my lord, they had already, my lord, fixed the bidders, my lord, who should be the successful tenderer, a bidder.
Election enters into tender also.
No.
Election things enter into tender.
No,
nothing.
No, my lord.
There is a judgment of the apex court. It will not affect the ongoing tenders.
No, my
There
lord.
is a judgment.
Can I put it in this manner, subject to my being corrected by your lordships? It is our specific case that, my lord, all bidders, my lord, sought.
That we understand. That is how they hushed up. They gave a short time because of the impending election. So that they wanted to complete.
That's all. Only for that limited purpose, nothing more.
That we understand.
Then, my lord, if your lordships, my lord, just have a look at the minutes, which, my lord, your lordships, my lord, just now, my lord, I pointed out. Please come to, my lord, the board resolution.
Is there anything like right to submit a bid?
My lord, my submission is, competition, my lord, must always be, my lord, fair. And, my lord, competition, my lord, there more competition, better it is, my lord, for the state.
That aspect we.
That's all. It is in that connection, my submission to your lordships is, if, my lord, the competition gets reduced, then, my lord, it will be, my lord, contrary to the interest of the state itself. My lord, can I seek your lord's indulgence? The judgment says. Not this. Not this. My lord, can I seek your lordship's indulgence to look at, my lord, see page 10. This is 2019. Sorry.
In Michigan rubber, something case was.
Yes.
there. Huh? Michigan rubber.
Yes.
They have set the parameters for examination of issues relating to validity of
Yes, yes.
tenders, etc.,
Yes.
etc.
But then, my lord, please have a look at this for a minute. 2019, 4 SCC 401. Please come to, my lord, page, my lord, 10. Please come to, my lord, paragraph 3 at page 13. There was, my lord, clause 25(8), which set out, my lord, as follows. Bottom, my lords, get that. I'll not trouble your lordships. Please come to, my lord, running page 28. Honorable Supreme Court, my lord, set aside that clause. It is not that, my lord, tender conditions, my lord, can't be, my lord, set aside. If the time given, my lord, is too short, can, my lord, the court intervene? That issue, my lord, is a matter, my lord, which is at large before your lordships. For all the reasons, my lord, page 23, para 28, we strike down clause 25(8) of the notice inviting tender. This clause being severable from the rest of the clause 25 will not affect the remaining parts. Judgment of the High Court is set aside and the appeal allowed. My submission to your lordships is.
No, was it a case of giving of short period?
No, my lord. This is not, my lord, this is not what I am submitting before your lordships is. It is not as if the tender conditions are, my lord, sacrosanct, terms are sacrosanct, courts have interfered. In fact, my lords may turn to the next judgment, where, my lord, our own High Court, that was a case, my lord, where the very KPC, my lord, Karnataka Power Corporation, my lords, get that at page, my lord, 24. That was a respondent.
Page
24.
24.
Yes, my lord, of the judgment list.
That very good.
Yes, ma'am. AR 1997 Karnataka 220. That was a.
Where your friend was arguing. Raghavan had appeared in that.
I had appeared.
Mr. Raghavan also.
You had appeared for KPCL, I had appeared for rest judicata against him, my lord. This was a case where coal, my lord, was to be, my lord, supplied from, my lord, the collieries. Tender condition was he must have, my lord, experience in road, rail, sea and, my lord, rail. Rail, sea, rail. Whereas, my lord, the coal was to be supplied only through road and not, my lord, and rail, not, my lord, through sea. So, my lord, the tender condition was set aside. Can I seek lord's indulgence to turn to, my lord, paragraph 18 at page 30.
Paragraph 18, but you are relying on single judge before division.
Lord.
Yes.
My lord, all that I can say is it is, my lord, can I put it in this manner, subject to my being corrected by your lordships?
We are respectfully looking into it.
It is not that, my lord, tender conditions are sacrosanct. That's all, my lord, only for that limited purpose, nothing more.
Yes, please read.
That more than that, my lord, I will not say that. Please come to page 31. bold portion, my lord, that paragraph, my lord, in the middle.
Yes.
Equality of opportunity should apply to matters of public contracts. State has a right to trade. State has therefore the duty to observe equality. An ordinary individual can choose not to deal with any person. Government cannot choose to exclude persons by discrimination. Order of blacklisting has effect of depriving a person, equality of opportunity of public contract. A person who is in the approved list is unable to enter into advantageous relations with the government because of the order of blacklisting. Citizen has a right to claim equal treatment, so on and so on.
So this must be in during the course of the tender process.
My lord, in this case, the tender condition was set aside. Can I persuade your lords to look at, my lord,
The
page 37?
controversy must have arisen in course of the tender process.
No, my lord.
While
No, my
considering the
lord.
bid
No,
of the-
no. Can I request your lords, just have a look at, my lord, page 24 again.
Let us, yes.
Please come to para 3. The petitioner has sought for the relief referred to above. In this petition, mainly on grounds. Firstly, on the ground that subclauses A and B of clause 4 of the tender notification at annexure M are illegal, arbitrary, and highly unreasonable, and violative of the right guaranteed to the petitioner under Article 14 of the Constitution. Secondly, procedure followed in the matter by issuing tender notification annexure M, which ultimately resulted in submission of the tender of the fifth respondent for the purpose of movement of the coal by sea rail route from Mahanadi coalfields, Talcher in Orissa to Raichur Thermal Power Station in Karnataka is vitiated on account of malafidus on the part of respondents 1 to 4. Petitioner has set out in detail the facts of sequence of events, etc. That, my lord, sea rail route. What was needed, my lord, was, my lord, only the rail route in this particular contract. Court said, my lord, this condition is illegal. My lord, it hinders competition. It, my lord, is violative of Article 14, and therefore, my lord, set it aside. This is only for the limited, I know, my lord, this is a learned single judge's order.
No, yeah, not that.
But therefore, my lord, I pointed out to your lordship, my lord, the judgment of the Honorable Supreme
All we
Court.
say is not correct.
No, my lord. No, my lord. I also with trepidation, my lord, I cited this. I know that. With trepidation, I cited this only, my lord, for the limited purpose.
Yes, I may say anything in open court, but that don't take it.
No, my lord. We have to, my lord, clarify all the doubts. My lord, can I persuade your lordships to turn to page, my lord, page 85. 185. This in the same
matter
compilation.
did not go in writ appeal.
Confirm, my lord.
Confirmed in writ
Yes,
appeal.
yes. It was confirmed in the writ appeal. 182, my lord.
182 in the
182, 1975. 182 of this very compilation, my lord.
The same company.
Judgment list.
75 Supreme Court.
Yes, my lord. Please come to paragraph 12 therein, my lord. Which one is it? What is it that you're showing? My lord, sorry, my apologies, my lord. It's 188.
188.
1 minute. Correct page, correct citation.
SJS business.
Yes, my lord. This is not the one.
This is for the proposition.
Who participates? 188 is different.
My lord, sorry, the same one, 182.
182.
In that paragraph 12.
Yes.
Running page, my lord, 185.
For the proposition.
That, my lord, the state.
Under Article
290.
Yes, my lord. 14 and 19. Article 298 of the Constitution, the executive power of the Union and the state shall extend to carrying on any trade and to the acquisition, holding and disposal of property and the making of contracts for any purpose. State can carry on executive function by making a law and without making a law. Exercise of such powers and functions in the trade by the state is subject to Part 3 of the Constitution. Article 14(6) speaks of equality before law and equal protection of the laws. Equality of opportunity should apply to matters of public contract. State has a right to trade. State has therefore a duty to observe equality. An ordinary individual can choose not to deal with any person. Government cannot choose to exclude persons by discrimination. My lord, my submission to your lordships is, if, my lord, I ask myself this question. Undeniably, my lord, 5 years is the duration of this contract period. EC clearance, WC, my lord, is yet to be applied. My lord, my learned friend now says they have applied. All right. Take 6 months, my lord, is what they have said. My lord, what was the unearthly hurry to, my lord? Because if your lordship now look at that report, which was submitted, my lord, because everybody wanted that, my lord, technological report, geotechnical report. Please look at, my lord, that report itself. My lords, get that at page 626 of the compilation, my lord, of the paper book. 625. All right, leave it. Six to 5. 6 to 6, sorry. 6 to 5.
6 to 6.
And my lord,
Comprehensive study of long-term power procurement.
detailed project report.
R7. Mr. Holla, is it annexer R7? Volume number.
1 minute, my lord. I'll submit to your lordship, my lord. Where is the techno?
So WAPCO's report is R5, page 592.
592. No issue. You can be at your ease. When there are many volumes, it happens.
Sorry, my lord. My
At your
apologies.
ease. It's a heavy matter. Annexer
Clause
R5.
1.4.
It appears Mr. Holla is referring to annexer R5.
Yes.
Page 592.
My lord, my apologies. In the list of dates I had given,
No issue. No issue.
wrongly mentioned as
No problem,
692.
no
I'm
problem.
sorry. I'll
That
make some
happens.
corrections and then we'll give you a lot.
Very bulky papers, no, it happens.
1.4. One- 640. Hmm?
648.
648.
Annexer A. Perhaps this you wanted to say.
That's what my.
Yeah.
One 1.4, my lord, at page 663.
663.
Yes, my lord. My lord, they have carried it out, my lord, between the period 2018 to 2020.
That is 1.4.
Yes, my lord. Geotechnical, my lord, geological and geotechnical investigations, the lab-based rock mechanics tests have been carried out during the period 2018 to 2020 by WAPCOs near NIRM, CSMRS, New Delhi, in the draft, my lord, DPR stage, project report stage. Then, please come to, my lord, paragraph, clause 4.8. (688). There are 3 tunnels. My lord, that's where the water has to flow into, my lord, the my lord, the
Tail race tunnel.
Yes, my lord. 352 kilometers of TR1, 3.49 kilometers of TR2, TRT2, 10 dia. Tail race tunnels have been proposed. Elevation along with the tail race tunnel varies from EL 475 meters near surge chamber, area EL 60 meters near so and so, so and so. Cover along with the tunnel varies from 437 meters to 22 meters. My lord, that's a height difference. Due to extreme inaccessibility in dense reserve forest, most of the stretches along with the TRT, that's a tail race tunnel, have remained unexplored during surface mapping. However, efforts have been made to take few traverse in and around the area. Again, paucity of rock outcrops due to presence of thick overburden and tentative contact between the two rock groups have been marked on the map from the available data and the downstream of powerhouse.
So difficulty is expressed even by the tendering authorities.
And my lord, they have not been able to do it. Then my lord, please come to my lord paragraph 4.10. That my lord runs into 7 kilometers, as your lordship said 4.8. at my lord page 693. One 1.7, my lord, 1,700 meters is 1.7 kilometers. D-shape main access tunnel has been proposed to reach the powerhouse service bay, fixed at elevation, my lord, 9.50 meters. Due to tough terrain condition and dense forest, majority of the tunnel alignment has not been accessed during the DPR stage mapping. Majority of the area is under thick cover of overburden. Proposed alignment is cutting across 5 numbers of westerly sources. Flowing nalas, where specific outcrops have been identified during the geological traverse. Therefore, my lord, and they also submit, my lord, where they have not been able to do it. Then 4.11. This is, my lord, cable access tunnel. So, my lord, tail race tunnel, they have not been, my lord, able to do it. Main access tunnel, not able to do it. Cable access tunnel is, my lord, page 694. CAT is 7 into 7 meters D shape dia, and the invert of the tunnel is proposed at elevation 134.60 meters. Sorry.
This is the study report of KPC only.
My lord, by the geotechnical, my lord, consultant, that WAPCO. 648, if your lords has come to, they have, my lord, given this to us.
Who is the author?
Author, my lord, my lords get at the bottom, my lord. 648, if your lords has come to. WAPCO Limited.
It's the government of India undertaking.
No, this study, it's a study, it appears to be study report.
Just a study report, my lord.
Report.
The petitioners or all tenderers, the person who is awarded has to do their own, for which costing is also included in the tender. It is just an assistance for them.
My lord,
Okay.
I asked myself this question.
I'll show the relevant clauses.
If this study has to be conducted without studying, my lord, how do I, my lord, submit, my lord, the financials? I ask myself. This is the problem. They have already, my lord, the cap is already, my lord, cut. Head is there. They want to, my lord, fit that cap into that head. That's our contention and submission. Please look at it, my lord. This is, my lord, from this, they carried it out from 2018 to 2021. I just read to your lordship, my lord, when they carried it out. My lord, I asked myself, my lord, please come to, my lord, page 663, para 1.4, your lordships have seen. 2 years, my lord, they carried this out. And yet, my lord, they said, my lord, we have not been able to, my lord, study, my lord, the tunnels, access the tunnel area, because tunnel, my lord, is the most important aspect here. It is in this.
We want to know.
Yes, ma'am.
While fixing the tender period with which you are not happy now.
No, yes, ma'am.
That's what. If you are happy, then you have no case at all. Now, how this period is prescribed in your, because it is indoor management issue. He will not know. How this period is prescribed? On what basis? Is it a normative? Or somebody will fix this date and we will fix that?
Well, the technical team has gone into it.
How that is done? How, any normative basis for that? the period of tender, how it should be fixed?
In fact, my lord, including one other aspect, what was pointed during technical pre-bid meeting, they sought for extension, my lord. We have
No,
given.
that will come
So
to.
therefore, what?
In
Yes.
projects like this,
Please, my lord.
which involves huge budget, a lot of the investment, etc. How you fix period for projects of this kind? The period should be so much. Is there any normative basis, or it is decided on contract to contract basis? On what basis?
There's no fixed term for, depending upon the contract, we fix the period, my lord.
No, who fixes that?
The technical team, my lord. Technical team, they fix the period, my lord.
So any kind of scientific exercise is undertaken.
My lord, for example, when they issue the tender, my lord, the technical team usually knows what is the period required for the bidders to submit the bid. Depending upon the nature of the tender, in fact, as per section 17, 30 days is the minimum, my lord, minimum. 17.2 says you can relax. We have relaxed it, keeping in mind the technical team thought that it's 21 days was sufficient. After hearing all the bidders, earlier it was 19, then they extended it to 21. And out of total 4 bidders who participated in a pre-bidding, there are 4 bidders, my lord, out of which 3 have participated. In fact, my lord, the question, the whole case revolves around the short point, saying that, my lord, only he not able to submit his bid till 3rd of May, because he needs certain clarifications. In fact,
sorry, not an argument. We wanted to know
what is the basis?
How is it? Is there some protocol, some normative basis for fixing for such and such contracts involving such and such efforts, endeavors? This should be the period. For others, this should be the period. Any normative basis based upon the experience which you have gained while working all these years? This KPC has been there since decades.
So therefore, by sheer experience, my lord, depending upon the tender, they have fixed 21 days, my lord.
Any scientific, my lord wanted to know, any scientific study as to what should be the period for?
I'll verify and get back on that. What is it?
There has been none.
You filed reply in the main writ proceeding?
Yes, filed.
I'm sorry.
Objections you have filed?
We have filed our objections.
So in that any sentence?
No, that question did not arise. That was not argued also, my lord, as to this aspect.
No, we argued saying that, blood, this is.
They argued we want third May.
Mr. Holla, there is difference. There is jurisprudential difference. Is it your case that the period being too short to be little, it is arbitrary and therefore bad? Or is it your case, too short a period is prescribed to exclude you from the fray?
Both. And that's our case also, my lord, before the learned single judge. Of course, the second part, my lord, he has not, though I had argued, he's not considered it.
No.
That's why I said, to beat that, my lord,
to exclude you, they did this. Is your version.
Code of conduct.
What is code of conduct to
No,
exclude
code of
the
conduct,
petition?
No, my lord. What I'm saying is, after that, they couldn't have finalized. My lord, please look at this, my lord, subject to my being corrected.
Just one submission, my lord.
10 years, my lord, this project has been, my lord, on the anvil for 10 long years. 10 long years. Even according to them, it takes 5 years, my lord, to implement this. Please look at, my lord, the time schedules now. 5 years it takes. They have not applied, my lord, for the EC, WC and other environment clearances. They are yet to apply. And their own, my lord, statement is it takes 6 months. Then, my lord, what is the hurry? And, my lord, they say, my lord, LOA, that's the letter of intent, my lord, and acceptance will be given, my lord, after the my lord, all the environment clearance, other things come. And they also say that, my lord, it may, once, my lord, the EC and WC clearance and the forest clearance comes, there may be changes in the entire, my lord, mechanics and, my lord, the length and the breadth and the entire thing. So, my lord, what is this hurry? Why, my lord, I ask myself this question. Is it not, my lord, that courts have time and again held that, my lord, competition, my lord, must always be encouraged. Anything, my lord, which would curtail competition, my lord, is violative Article 14. And, my lord, in this connection, if your lordship, my lord, again have a look at, my lord, page 517. There is no technical, my lord, consideration of this. They simply say, my lord, to expedite the process, my lord, we have now said we have fixed the short tender. Please come to, my lord, the page, my lord, 504 it starts. That's the note sheet of, my lord, KPCL itself.
Volume?
Volume, my lord, 3, my lord. 3. .504.
R2, annexure R2.
Yes, my lord. Please look at 2, paragraph 2. 255th board held on 2010-2016 accorded approval to award the work of preparation of the detailed project report for Sharavati stored pumped storage scheme to Messrs. WAPCO. Then, my lord, WAPCO gives it in 2021. Para 5. 37th, my lord, TAC and the 315 technical committee meeting held on so and so have reviewed the DPR, recommended to place the DPR before the KPCL board for approval. 288th, my lord, KPCL board approves, my lord, held on so and so accorded in principle approval. Lord, I ask myself this question.
No, what you want to say from this?
Look at the timelines. My lord, what is the unearthly hurry? They give, my lord, the technical, geotechnical report. That says, my lord, all these are not, my lord, there. Tunnel, my lord, they have not, my lord, surveyed at all. One has to do it. Does it not take time?
My lord, Apex Court says, at least in 3 judgments.
Yes, ma'am.
That electrical power is the lifeline of people.
Absolutely, absolutely. I agree with your lordships. I entirely agree.
Basically, for 50 or 75 years ago, we did not much need power at all. Power from the sun was sufficient.
Yes, ma'am.
And sun also.
Yes.
But now, for everything, power is necessary.
Needed. Question, my lord, I can understand if, my lord, this project was to be completed day after tomorrow, 1 year later. This is, my lord, a 5-year project, even according to them. EC, WC, my lord, the environment clearance, my lord, not applied. It takes 6 months, my lord. Their own objection statement, I'll point out. They say it takes about 6 months for all those clearances.
According to you, what should have been the period?
My lord, May, my lord, is what we have said, 3rd of May, 5th of May.
3rd May. To be
90
exact.
days.
3rd May.
90 days, my lord, is what we said.
And you agreed to give that period?
No.
No, you did
No,
not.
no, no.
23 February was the last date.
Yes. 21st, my lord, was the initial one. They, my lord, extended by 2 days by corrigendum.
That's 17 February.
So that, my lord, they can negotiate with the electricity, with the EM manufacturers, and then arrive at a commercially viable.
Please come to, my lord, 517. 507, same note sheet. Paragraph 34 at the bottom. To expedite implementation, Saravati PSP, it is proposed to invite short tender by adopting observations to STPC. There is no, my lord, technical, my lord, committee which has gone into all this to say, my lord, how much of time is needed.
What is that EEC at page 518? Who has prepared this note sheet? Who has scanned this note sheet?
Executive engineer.
Executive engineer, my lord.
So technical man.
They're technical.
My lord. Question is, my lord, executive engineer, my lord, whether he is, my lord, even according to them, they did not have the capacity. Sorry.
And please see note 40 also, my lord.
My lord, please come to page 520 of the same volume. 520.
Just 519 may also be, sorry. 519. Note number 40, my lord.
Discussed, considered the
Notings.
in pre-paras of the office note, para
36.
36 of the office note, and may kindly be approved.
Who-
Let us go back to
Who
36.
who said this?
Not this is.
Board.
MD, ma.
MD.
MD.
MD, ma.
Is he technical hand?
Your lordship, may kindly
No, my
see
lord.
Athletic.
He is an
518
IAS of.
Page 518, my lord. Page 37. It is superintendent engineer, civil design, who has given this, my lord. Page 37. I mean, page 518, serial number 37.
Item 37, note
37.
the 37.
Please, ma'am, note 37. Is a technical person, superintendent, Roman 37, superintendent engineer, civil design. Then page 519.
Chief engineer.
Page 519, serial number 38, chief engineer, electrical design. So all these technical people have gone and put up this note, Manoj. After that, the MD comes to the conclusion based on this, Manoj.
Discuss.
My lord, I ask myself this question. Please have a look at, my lord, again the note sheet. Do they say, my lord, that the geotechnical report does not, my lord, indicate anything? It has to be, my lord, studied. It takes time. Not one whisper anywhere. They have not considered anything. My lord, they simply, my lord, somebody approved, my lord, the assistant executive engineer approves, my lord, he has approved, therefore I approve. Then, my lord, the other engineers approve, and then, my lord, it's placed before the board. And not one whisper, my lord, anywhere of a discussion or, my lord, of reasoning.
So you have two contentions now we have done as we understand. The first one is the judgment which you have quoted, which again refers to E.P. Rayappa. It's very arbitrarily fixed. Is your first contention. The period being too short, even to study and make a rational decision as to whether I should bid or not.
No. I will bid, but to, my lord, give this, my lord, please look at it. What is?
That's what I'm telling you.
No, financials, my lord. I'll put it in that manner.
In other words, any state venture which is to be accomplished by involving the citizens, by tender process, etc. It should be very reasonable in the sense that those whom you expect that they should come to the fray should be in a position to make a rational decision. What is the likely cost of the project? What are the things to be done here? Whether I can, without studying, can I bid or not? These aspects are to be duly addressed by the state entities, is your contention. That opportunity having been not given to you, you have been deprived of the participation in the tender process appears to be your contention.
Correct.
That way.
Correct. And, my lord, I have also said of mala fides.
That's what.
They have already, my lord.
To exclude you, they did all this exercise, is your contention.
Yes. And, my lord, there were, my lord, 3 bidders according to them. 2 of them, my lord, did not even participate in the pre-bid meeting. One of them, my lord, is not even, my lord, he has never carried out any, my lord, work of this nature. And what also has happened is the 8,000 crores, my lord, comprised of nearly about 3,700 or 800, my lord, is the civil engineering. Balance, my lord, is the electromechanical engineering. Electromechanical engineers, my lord, there are only 4 people, my lord, in the entire, my lord, country who have the capacity. They themselves came and said, my lord, time given is short. Their own consultant, please come to, my lord, running page 702, my lord, volume 4.
No, they had asked for time. Is not disputed by the other side.
Not to,
They had asked for time.
Yes,
But they say we have given 2 days by
2 days.
order, by corrigendum dated 17 February. That's what, 2 days you have extended. Instead of 19, you have made it 21.
My lord, the electromechanical, my lord, contractors, one of them, my lord, is void.
From
They-
21st, we made it 23rd.
From 21 to 23rd it becomes,
Just 2 days
not 19.
extension.
21 to 23rd.
19 days to, my lord, 21 days. If your lordship, my lord, my submission to your lordship is 4,000 crores, 3,700, 800, my lord, is the civil engineering. Balance, my lord, is the electromechanical engineering. Even the electromechanical engineering, my lord, there are only 4 people in the entire country. BHEL, my lord, gets disqualified. Out of the 3, every one of them said, my lord, time given, my lord, of 30 days is too short. 21 days is too short. Every one of them.
Where are your allegations about mala fide in the petition?
My lord, as far as the mala fides are concerned, my submission to your lordships is that, my lord, one.
Legal mala fide
Yes, my lord.
or personal mala fide? What mala fide you had invoked?
Even if it is Malay in law, where is the everment?
My lord, everment. Please take, my lord, the learned single judge's order itself, my lord, says.
How you have structured your ground?
Not structured at all.
There can't be a circumstantial mala fide, like criminal law.
That's what is being urged.
That is what they are. Nothing like that in concept, at least to me, unknown, circumstantial mala fide. Mala fide has to be pleaded, whether it is factual or even legal malice. In specific.
Rejoinder, if your lordship come to, my lord, page 607.
Rejoinder.
Writ petition itself, my lord, not here.
You have taken up content?
Yes.
Which is that?
Let us.
Page, my lord, 607. Volume, my lord.
So in the rejoinder.
Yes.
Yes.
Volume 4, my lord.
Volume 4, yes.
6. Sorry, my lord, 629, my lord, if I am not mistaken.
629?
Yes.
Volume 4?
Yes.
That is in rejoinder?
Yes, ma'am.
Can mala fide be taken as a ground in rejoinder?
Yes, my lord.
It appears no.
Please come to para 3, page 629. 629, my lord. 629.
629.
Volume 3?
Yes, ma'am. Volume 4, my lord.
4. Yes.
Last 3 lines, my lord. Respondents conduct in respect of the tender process elect and continue to lack bona fides.
CPC. Which paragraph, Mr.
My lord, para 3.
Para 3.
That's all. Which paragraph? Show on there.
It's a case of lacking bona fide.
Bona fides. And then, my lord, please,
mala fides.
my lord, please come to, my lord, page.
There is a difference between an action lacking mala fide and action being tainted with mala fide.
My lord, this is, my lord, I must,
that's
what is not there, my lord, I should not, my lord, tell your lordships. What is there only I can tell your lordships. Now, please come to, my lord, another paragraph at, my lord, H. That is, my lord, volume 1, page 105. Writ petition, my lord, paragraph H.
Volume 1.
Volume 1, page 105, bottom.
First one.
My lord, H, page 105, bottom. Respondent is bound to take into account all relevant factors, ignore all irrelevant factors in coming to its decision. The present case, condition has been incorporated on wholly extraneous grounds, which are unsustainable in law, based on irrelevant factors and taking into account and relevant and not taking into, without taking into account relevant and material factors. Respondent, in seeking to complete the tender process in an unreasonably hurried manner, has completely given a go by to the relevant criteria and lawful objectives that ought to motivate the stipulation of the tender conditions and bid process, namely to attract wider competition so as to enable award of the bid to the most suitable bidder, that is the best person, best price, to ensure public exchequers provide a highly competitive price and best value for the development of the project and of this scope and nature. Respondent has ignored grave ramification of its actions in stipulating a timeline that is impracticable and impossible for capable and competent bidders to meet, as it is anti-competitive. Then, my lord, paragraph N, condition, my lord, unduly favors, page 108.
H does not speak of mala fide at all.
My lord,
It speaks of lack of relevant
that's right.
factors, etc.
My lord, mala fides, my lord, if your lord is asked, my lord, then we, my lord, page 109. That's the assertion that we have made.
Page 109.
109, paragraph V. Court, being the guardian of fundamental rights, is duty bound to interfere where there is arbitrariness, irrationality, mala fides, and bias. Present case is ripe for interference by this honorable court to protect the interests of the public exchequer. More than that, my lord, we did not have, my lord, at that time. That's why, my lord, when we had to file a rejoinder, because who was coming, whom they were wanting to, my lord, favor.
Where this first sentence is the proposition of law.
Correct, my lord.
To attract this proposition,
I
where is
must
the
plead.
fact matrix?
Plead.
Fact matrix, Bekala.
This is, my lord. My lord, your lordship asked me, I said, my lord, this, more than that, I don't want to say anything.
What malified is the answer?
At any rate, my lord, I have said, this is, my lord, anti-competitive, that, my lord, this. Then, my lord, can I request your lordship, they can look at, my lord, 2 more judgments and I'll, my lord, rest my case. Please come to, my lord, the judgment list if your lordship, my lord, have.
This court has taken the view.
Yes.
Very old judgment, much before perhaps I entered the bar. The rejoinder is a reply
to objection.
the statement of objections. And there you cannot take a new ground. There is such a judgment.
That is, my lord, what your lordships are saying is under the civil procedure code.
Because we have adopted
Correct,
CPC under Rule 39.
Yes, correct.
That's the reason.
Correct, my lord. That is true. No, but favoring certain bidders, my lord, we have stated that, my lord, in our writ petition itself.
You have stated that?
Yes. Please come to, my lord, running page 108 and annexure, my lord, by paragraph N. That's what I pointed out. Condition unduly favors some bidders over others without any lawful basis.
It lacks the thorough of pleadings.
And, my lord, annexure M also, we says that, my lord, they are trying to favor one bidder over the other. That's, my lord, I can only, my lord, bring to your lordship's notice what is there and what is not there, my lord. I shouldn't, my lord, say that. My lord, if your lordships come back to, my lord, the judgment list for a minute. Sorry. My lord, can I also request you, lord, to look at page 702? Their own consultant also said, my lord, 90 days is needed. Volume 4, my lord. already said. Don't worry. Relax. Relax. Volume 4,
702.
page 702, my lord. 702.
704.
702, my lord. 702, volume 4. This is, my lord, by Voigt. This is one of them, my lord.
Extended for at least 90 days.
Yes, my lord, would you allow to look at the first paragraph
The
itself?
deadline mentioned in above referred NIT.
My lord, please look at the first. This is to bring to your kind notice that Voigt Hydro has been supporting Karnataka Power Corporation Limited and its consultant for Sharavati PSP and many other hydro and PSP projects from the very conceptual stage of the project since the last many years. We have been regularly providing technical inputs and support to KPCL in the form of alternative evaluation, budgetary proposals, providing inputs, arrangement of PSP technology.
But this is after the tender notification was issued.
Yes, yes, 22nd of February.
Who is the author of this?
Voigt, my lord. Voigt is one of the electromechanical. My lord. There are 3, my lord, persons who have the capacity.
No, who is he? Who is person who said this?
One of the E&M contractors.
He is one of the contractors.
Of the E&M, the three, my learned friend mentioned, my lord. One is Voigt.
Another is
the other
G.
Bidders.
No, my lord.
They tie up with the bidder to submit a bid.
No, they are also bidder.
My lord,
Bidders only.
Bidders only, they are also.
Because they claim under the bidders.
Yes.
E&M, my lord, contractors, there are, my lord, only 3 in the entire country. They have to, my lord, tie up with an E&M contractor. This E&M contractor, my lord, Voigt, was, my lord, their own consultant. In the first paragraph, your lords get that. Very first paragraph, it says that, my lord, we have been the consultant for, my lord, the petitioner, my lord, the respondent, for Sharavati, my lord, PSP itself. And they say, my lord, the last paragraph, last but one para, 90 days, my lord, at least 90 days is required for the submission of the proper bids. Therefore, my lord, in the light of this background, my submission to your lordship says, my lord, please have a look at, my lord, a few judgments with regard to the time stipulation. Not the first is, my lord, page 162. No. Time extensions, time stipulations. Time. My lord, speaking order, your lordship wanted to know, my lord, sorry, 105. Sorry, not 105.
Justice Arvind Kumar's
Yes.
judgment.
Paragraph 33 at page 146.
Page 105.
105 at 146. Starts at 105. At page 146, my lord, if your lordship turn to para 33. Bare reading of Rule 17 would clearly indicate that tender inviting authority should ensure that adequate time is provided to the bidders for submission of their tender, and the minimum time that is to be allowed, time to be allowed between the date of publication notice inviting tender while publishing the same, either in the bulletin or in the e-portal. Clause A of sub-rule 1 of Rule 17 would prescribe 30 days as the minimum time for tenderers, value up to 2 crores, and tenders in excess of 2 crores, the time prescribed was 60. That has been changed to 30, 15 and 30. When this judgment was given, it was 30 and 60. However, sub-rule 2 enables authority superior to the tender inviting authority to reduce the time stipulation in sub-rule 1 And while undertaking such an exercise, tender inviting authority has to record reasons in writing. Sub-rule 2 of Rule 17 does not indicate that the reasons by the superior authority should be elaborate, etc., etc. Then, my lord, paragraph 40.
Thus, there cannot be any stringent jacket.
That's right. That is
Formula
true, my lord.
prescribed for the manner in which
Correct.
the reason.
Correct.
This is the judgment which I had when I said that.
Oh. My lord, wider participation, my lord, is one of the things, my lord, that is always, my lord, encouraged by the courts. If your lordships turn to, my lord, page 167. This is, my lord, 2004. 7 SCC 151.
Page number?
My lord, 167 it starts.
Gajraj Jain.
Yes, ma'am.
Paragraph?
My lord, 15, my lord, head note itself, my lord, says that, my lord, ultimately, my lord, it is competition, my lord. I don't want to, my lord, dilate further on that. I think, my lord, the better judgment is that.
What you say, it should be, there should be wider
Yes,
competition, so
naturally.
that quality will
That's-
come out.
That's right. In fact, 8,005, my lord, was the bid amount, my lord, the amount. But according to them, my lord, some it went up to 10,000 crores.
No, reduce.
And then, my lord, got reduced.
No.
Got reduced to 8,600 and odd. All in one day only. Entire process of tender evaluation, technical evaluation, financial bid, everything was done in one day. That also, my lord, we have stated because that, my lord, was done after, my lord, matter was before your lordships. When we moved your lordships, till then, my lord, they had not, my lord, opened the bids at all, technical bid or this. After that, within a day, my lord, everything, my lord, was processed and completed. That's another, my lord, malafides, my lord, we have filed an amendment application, my lord, we have raised that, my lord, the specific contention as well.
So you are saying which Darwin had said in his Origin of Species, natural selection. Natural selection requires abundant competition. You say reasonable competition there should be.
Lord, therefore, my lord, my submission to your lordship says that, my lord, the time given, my lord, would your lordship look at, my lord, one judgment for my lord's consideration. That is, my lord, running page 188. 188, 2004, 7 SCC 166.
SJS.
Yes, sir. Para 18 at page 196. Adequate publicity.
196.
196 at the bottom. Adequate publicity to ensure maximum participation bidders in turn requires that a fair and practical period of time must be given to the purchasers to effectively participate in the sale. Unless subject matter of the sale is of such a nature which requires immediate disposal, opportunity must be given to the possible purchasers who are required to purchase the property on as is varies basis to inspect it, give considered offer with the necessary financial support to deposit earnest money and pay offered amount if required. The gist of this plot is ultimately, my lord, I don't want to, my lord, unnecessarily burden your lords with authorities and authorities. Competition must be, my lord, encouraged. And for competition, my lord, sufficient time ought to have been given. Voith itself says, my lord, 90 days is to be given. Not, I mean, we all of us have said, my lord. I also have stated that. Therefore, my lord, Yes. My lord, now, please look at, my lord, the conduct of the KPCL itself. My lords may just see, matter came before your lordships, my lord, and I moved your lordships. At that time, my lord, they had not opened the bids at all, admittedly. Technical evaluation, financial evaluation, everything was done, my lord, on a Saturday, Sunday, my lord, and both of which are working days. And Monday morning, my lord, they said, my lord, when we came before your lordships, they said, my lord, we have already opened it. These, my lord, hurry-burry itself, my lord, is, in fact, courts have time and again held, if there is, my lord, undue haste, mala fide days can be presumed. Enough judgments are there. I don't want to, my lord, unnecessarily burden your lordships with authorities. Look at the way, my lord, they have gone about. I moved your lordships on a Friday evening. Your lordship said, yes, I'll take it up on Monday. Saturday, Sunday, my lord, we give them notice. Saturday, Sunday, my lord, are holidays. Monday morning, they say that, my lord, everything is done and opened and completed. My submission to your lordship is this again, my lord, is one aspect which we have, my lord, pleaded because this is a subsequent event. And we have, my lord, in our amendment, my lord, have raised, my lord, those grounds as well, my lord, before your lordships.
No, conduct of a litigant under the shadow of a judgment favoring him. From that, what can be inferred?
My lord,
they were doing it under the shadow of the impugned judgment.
Correct. Your lordships were seized the matter Friday, my lord, when your lordships, my lord, I moved your lordships, they were present here. They were aware that, you know, your lordships were to, my lord, consider the matter on Monday.
Only this you can say to counter their possible argument that now we have marched forward.
That's all. That's all.
Nothing
More
can
than
be
that.
done. That argument, perhaps arguably, you can.
That is one. Secondly, my lord.
Not for mala fide.
No, I'll tell you, lordships. Can, my lord, in a day, my lord, Sunday is a holiday. Saturday, my lord, is. Can, my lord, it be done in one day, my lord? I ask myself. Technical evaluation, financial evaluation, everything. And, my lord, according to them, there were 3 bidders. One of them, my lord, gave 9,000 crores. Obviously, the other 2 must have given, my lord, far higher than that. They, my lord, negotiate. My lord, reduce it to, my lord, by 600 crores, my lord, 400 crores, and arrive at 8,605 crores of bid amount, which is accepted. It's 8% more than the project cost. Therefore, in fact, there is also one more. Of course, this is a technical this thing. We have placed, my lord, before your lordships, my lord, in the rejoinder that, my lord, every tender exceeding 50 lakhs has to have the approval of the board in consultation with the technical committee. That has not been done is another aspect, my lord, we have placed before your lordships. That's all.
In your rejoinder, you have taken up that contention.
Yes, because, my lord, it is a subsequent event.
After they filed,
yes,
you came to know.
Yes, that now here, my lord, before my lords in the writ appeal. Therefore, my lord, my submission to your lordship is, my lord, this is a matter, my lord, where requires. What is it?
We tried what their cases before we should not have done before the interim order. We should have waited for the interim order. Their cases.
That is not my case, my lord. When your lordships are seized the matter, my lord, authority must, my lord, your lordship specific, my lord, when it was moved, your lordship, my lord, was moved and on Friday at, my lord, because the judgment came, my lord, at 3:30 to 3 o'clock, 3:30. I moved your lordships at 4:30. My learned, sorry, the next morning. They were present here.
He didn't put us on notice. He happened to be.
All right. Whatever it is, my lord, whether I put them on
court every day, my lords.
As a advocate general, we can be very watchful of all
we must compliment him, my lord, for that. And we wrote to them also, my lord. We wrote a letter saying that, my lord, this your lordships had directed that it be listed on Monday morning. Therefore, please hold your hands. Don't do anything, my lord. This is one aspect, my lord, which I'm pleased about. In fact, technical evaluation in all those, my lord, that what I submitted to your lordship, my lord, page, what I had already submitted, the page numbers, 888, my lord, where other projects, 1 month, my lord, required, my lord, for minimum evaluation of their tenders. Minimum 1 month.
30 days.
Yes. For evaluation, my lord, not my lord for submission of bids.
Evaluation.
Yes. My lord, please look at it. This is, my lord, a technically, my lord, highly technical project. Evaluation, my lord, in 1 day, entire thing.
limited submit so and so, it is open for the petitioner. Second paragraph, my lords, for the petitioner also to submit his bid by the next date of hearing. So what had happened, my lord? They said that they want to argue the matter. We said, okay, let them argue the matter, but submit your bid at least.
That you were given offer, but.
And we have written a letter also to them pursuant to this interim order, kindly submit your bid. And we also said you have queries, kindly give your queries also.
Where is that? Letter?
That letter is at page number 706, I think. 706. 706. Oh, that is volume 4. I'm sorry, we should keep telling the. Court office, volume 4, 706. I think the different volume, it's volume 4. Man.
Yes, volume 4.
I think it's just a letter, one page. Same, volume 4, 706. Volume number is written right on top on the right hand side.
27 to 24.
Yes, I'm grateful to my.
706.
706, please. Can I read it? Pursuant to the hearing held on 26 February 2024 and WP number so and so before the Honorable High Court of Karnataka, we are in receipt of advice of our advocate appearing in the matter, and accordingly it is to inform that you may submit your bid on or before 1/3/2024 up to 1:30 p.m. for the subject tender. Further, it is also to inform that in case any queries pertaining to the tender, please contact the undersigned for clarification. This letter is issued without prejudice. My lords, we can't force him to submit. Here a person is reluctant to submit his bid. He says, I will only argue my case. I will not participate unless you give me time till 3rd May.
But if you are right otherwise in fixing the time limit of 21 days, why should you do this?
No, the question is, we wanted to, my lords, we want to avoid litigation, my lords. If, as my learned friends argued,
No,
we should.
That runs counter to R.D. Shetty.
So therefore,
what you have done runs counter to R.D. Shetty, because had you given this to the public at large, many would have participated. All are under the impression that the period is only so short. Perhaps we will not be able to
no,
do
there
it.
were only 4 bidders, as my learned friend. Out of 4, 3 participated, 1 came to court. We wanted to avoid litigation.
My lord's question is,
or you wanted to get rid of 30 days period.
I'm sorry, ma'am. We wanted to get over the. My lords, we thought if you wanted the rule 17 to gives us the power. That is why, my lord, we said rule 17 says 30 days. We said to avoid litigation, we said, okay, fine, you participate as well as you give whatever queries. All that was argued today, we wanted to put a quietus to it, saying that tell me what is your problem, we'll solve it. My lord, the principle of R.D. Shetty would apply if a third party had come before your lordships and said, I was not given this opportunity. That is not the case here.
no, others may come because of this.
Your lordship may deal with it as and when they come. As on today, it is not the case of anybody else.
Not like that. In R.D. Shetty, where one paragraph from American Supreme Court judgment, Justice Felix Frankfurter's judgment is referred in that judgment. There, Apex Court said, loss of opportunity. Now, this opportunity you are giving only to one. When my Honorable Chief Justice is asking now, if at all you could be so liberal, why you did not stipulate it in the tender document itself, so that all these things would have not arisen that way?
Manoj, if I may put it this way, Manoj, there were 4 people who participated in the pre-bid meeting, out of which, as your lordship says, 3 people participated who participated in the tender proceeding.
No, only one. Other
3.
2 did not. Other 2 did not participate in the pre-bid.
No, I'll show they participated. I'll point out that also, Manoj. Answer my learned.
So your contention is you had given whatever he was complaining of.
Correct.
That complaint would wither away because of your offer that now you also participate. He did not.
In fact, even in the final order also. So 26 March, 4th March, in fact, Manoj, till the judgment was reserved, that offer was there for my learned friend. Till the judgment was passed. The Lordship may kindly see the order sheet which clearly discloses 26th February, 1st March.
So you wanted to give quietus to this
Quietus to the
litigation so that
litigation.
it could have.
My lords, we are reeling shortage of power in state. Your Lordships are aware of the section 11 order, my lords, where we have passed an order that nobody should transmit power outside the state. In fact, that has been struck down also, my lords, section 11 now, saying that you cannot restrict the power generation from transmitting power. We have acute shortage of power. And in fact, my lords, only till June, July, my lords, work can go on. After that, monsoons will come. These are the urgencies which we are at, my lords. My lord, here is a case, reluctant, and one other very important, my lord, he is only, according to his own petition, is not eligible or qualified to tender as on the date of filing the petition or even today, because unless he has a E&M contractor, that is the technical, civil and electromechanical, he cannot participate in the tender. Even today, he doesn't have a E&M contractor. His whole idea is to negotiate with an EM contractor. I'll point out from records till he gets an EM. I understand, my lords, if the EM contractor was a petitioner before our lordship saying that both of us want to bid, we need this. That is not the case. Only a civil contractor who is not eligible to participate as on today also.
Petition is not eligible.
Not eligible as on today without an E&M contractor.
Till you invite.
No, I thought it with the JV will do. Along with the JV, you could have come and submitted his tender. Along with the JV, you could have come and submitted his tender.
Occasionally, if you are right, you are right. Why should you deviate from your stand by inviting?
Not, my lords, we want to avoid litigation, my lords. On the basis we are trying to be fair, my lords, as fair as can be possible. That cannot be that cannot be pointed at me, my lords. To being fair and giving an opportunity, saying please come, bring somebody and do. We'll answer your queries even now, my lord. That cannot be founded fault or held against me, my lords.
You are apprehensive about your stand that we have not given 30 days. It's mandatory in the rules.
To overcome that, they should have.
My lords, to avoid, as I said, my lords, to avoid judicial scrutiny, avoid put an end. When we are saying that urgency, when urgency calls for urgent decision to reduce litigation. When we said.
Honorable Chief Justice is asking, if you are very sure that he is not eligible, where is the question of asking him to submit the bid?
No, I'll go down, my lords. When he had to submit, even if tomorrow if he has to submit, he has to submit with a joint venture partner. I'll show from the document. No, forget the document. His own pleadings in the writ petition says that I am not eligible. I'll point out that. Show the paragraph number.
Page 96.
Page 96, volume 1.
You have said that he is not eligible.
Yes. It is not my, it is his own case.
Page 96.
96.
Page 96.
23. 23.
96.
Petitions, sir.
Yes.
96, sir.
23.
23, page 96.
97.
Starting at 96.
Para 23.
Please, the respondent has taken bona fide efforts to endeavor to submit the techno-commercial bid within the grossly inadequate stipulated in the NIT. However, the scope of work set out in the NIT requires both civil work as well as electromechanical E&M and hydromechanical works to be carried out on turnkey basis. There are two separate service lines with civil work on the one part and EM and HM on the other. As such, the civil contractor, such as the petitioner, as well as other capable and competent bidders, would be required to avail the services of and partner with E&M company to be able to carry out the complete scope of work contemplated in the NIT. Since the project is to be completed on turnkey basis, without getting a firm techno-commercial offer from E&M agency, as EPC would not be in a position to submit its bid. Your Lordship, according.
Tie-up is, what he is saying is, on his own he cannot, but he is entitled to have the tie-up.
That is
then
what,
he becomes eligible.
Correct.
That's what he was saying. It's not that I am completely ineligible and still you entertain our
No,
petition.
Petition.
Never he said that.
No, no, not that. I'll clarify my submission once. About what your lordship, that is what he has said. What I am trying to put across is, he doesn't, petitioner before your lordship is only a civil contractor, does not include a E&M contractor. Then only the petition would become maintainable in the sense, the eligibility would have been there, saying that both of us would submit our bid, time is sufficient.
So this tie-up was to be shown at the time of bidding itself.
Bidding itself. Bidding itself, he did not add on that day. Even as on today, it is not his case. He's got a E&M contractor with him. Next paragraph is also important. Para 24 is very important. There are 4 E&M players presently operating in the country: BHEL, GE Group, Voith Group. That your lordship pointed out that letter which was read. After the tender, they get a letter issued by Voith saying that we want 90 days. Before the tender, nobody says that we want 90 days. And Andritz Group. There are only, these are the only E&M agencies who have executed all major projects across the hydro and pump storage sectors across India. They are multinational, internationally reputed agencies with extensive experience and expertise in handling large-scale EPC contracts for hydropower projects globally with a proven track, so and so. Then as such, there last 3 lines follow. As such, there are 3 qualified E&M companies who are capable of providing services of the nature, complexities, and magnitudes and EM works contemplated, namely Voith, Andritz, and GE. They have participated in the pre-tender bid. Then all this Voith, Andritz, and GE. Page 97, my lords.
Yes.
These 3 people have participated. They have not come before my lords and said that time is not sufficient. It is only one civil contractor, my lords, who comes, who is not eligible. And he has not partnered with any one of them. Even according to them, he can partner only with any of these 3. Assuming tomorrow he has to be eligible, he can partner only with any of these 3 bidders to become qualified to participate in the bid. So he fixes the day as 3rd May.
Para 25 may be read.
I'll read 26 also. 25. So petitioner has been in discussion. This is pretty important.
Others, he was in discussion. They were saying period given is very short. Therefore, we are not in a position to tie up with you.
No, therefore, we have to lead evidence as to this, unless Voith, Andritz, and GE is before your lordships. Your lordship may kindly see, my respectful submission is, I would appreciate this saying that any of these 3 people come before your lordship saying that time is insufficient. We are in discussion with him. We want to participate. So therefore, these are and one very important thing, my lord, he was negotiating with Voith to say that I'll enter only under an MOU. I will not enter into a joint venture agreement with you. Because the discussion was for a commercial purpose, you were discussing, saying that I will not take you as a joint venture partner, but I will take you only on an MOU where you supply the goods to me. That is why he wants time till 3rd May. Your lordship may kindly see his letter dated page 405. This discussion is to be read along with page 405, volume number 3.
He's not, this is letter 3. He's not asking for more 90 days. He's not asking for 90 days.
Go to
405.
405, please, volume 3. Your lordship may kindly see, this is a letter at 405, at 406, my lords. One important fact, my lords, when he writes a letter to KPCL, he does not, as on 5th February, he doesn't seek for time, my lords. He doesn't. What is crucial is no time is sought for extension, as on 5th of February, in this letter.
Post corrigendum he sought for.
No.
Before that. Before 17 February.
Yes. I'll read this one, para 2. We are eager and excited to have the opportunity to associate with KPCL to transform this project from a concept to reality. However, I have gone through the NIT, we have observed that there are some clauses which are restrictive in nature, hinder the participation of many capable construction companies. We submitted our suggestions on the set with the NIT was at the draft stage. However, unfortunately, the same has not been incorporated in the final tender document as issued. Conditions in NIT would result in restricted and or disabling participation of otherwise capable and competitive bidders would be unreasonable and contrary to public interest. We would humbly submit your good self to revisit, review and modify below mentioned key conditions of NIT. What he requests is, this is important man. Based on our preliminary discussion, the same discussion in para 25, with reputed manufacturers of E&M operating in India who have requisite techno capabilities, qualifications, are willing to join only as specialized equipment suppliers, subcontractors to the civil partners. They have completely ruled out partnering as consortium JV basis. It is their understanding that the MOU partner provides the necessary route to support the bidder as specialized equipment supplies by subcontractors. Next paragraph. In this case, it is pertinent for KPTCL to confirm upon the equipment supplier, HM equipment supplier who meet the technical requirements as tenderers can be supported as bidder as specialized equipment supplied by subcontractor. So what he wants to do is, as per the tender, they should.
Has he sought for extension of period in this or
No,
He has
no,
not.
he has not. My lord,
Where
this
he
is
said this.
nowhere
This
has
was
it-
written on 5th February.
5th February. Next paragraph, my lord. This is also important.
Lord, 359, same day, another letter is there. This is a clarification. Lord, they sought, if your lords recollect.
Two letters he had
Yes.
sent. One is for clarification, other is for extension.
Extension. Lord, they sought, Lord, 270 clarifications were sought from, Lord, all the bidders. 4 bidders, Lord, sought. This is one such clarification sought.
Your lordship, I'll come to 350, page 406, my lords. Your lordship, may kindly see, my lords. Last but one paragraph. It is further requested, page 406. my lord. Yes, sir. 350, that yes for extension. Yes, sir. This is what- Page 406, my lord, just one more paragraph, can I request, my lord, page 406. Next, it is further requested, my lords. My lords got it, is page 406, it is further requested.
That the bidders
Be allowed to propose more than one qualified equipment supplier in each E&M GIS so-and-so at the bid stage and the firm up one supplier after the award of this project. This would avoid any monopoly of single suppliers and enable bidders to submit most competitive bid. Similar approach was followed in a major EPC tender by Hydel projects by NHPC. So therefore, what his requirement for 120 days or 90 days is two more main thing, my lords. He wants to say that don't bring in any JV. Let them be only a supplier. Second thing, supplier can be more than one. And supplier will be decided after the tender. These are the terms which he wants to incorporate in the tender document, for which I confess, my lords, he has asked for 90 to 120 days. The discussion mentioned in writ petition para 25, as he says that preliminary discussion should be read into this. This is the discussion which he was going about for the purpose of one. It is not his case, geotechnical, all this. It is a commercial discussion.
In other words, the ground on which he had sought for extension of the period, he said that period should be longer. Is not on that ground which he has pleaded before the learned single judge, nor before us.
Please.
It is on this ground. It's relatable to this aspect of the
it's
matter,
only
coupled with that pre-bid meeting.
Here is a case where the petitioner, the petition.
359, my lord, makes it very clear.
I'll come to that, my lord. I'll read.
359 at 360.
I'll explain that 359 why he has asked.
359.
Yes, at 360.
Where is
In
that?
fact, my lord,
Where is that?
same page,
Extension,
same
sir?
volume.
360, page, paragraph 5,
Yes, my lord. 5.1.
5.1.
Timeline of 18 days with the preparation submission so and so proposed.
That the reason is why he splits same document, two letters,
Because one, my lord,
two independent.
270
My lord,
clarifications are sought from, my lord, from everybody. So similarly, my lord, I have also sought. So I'll point out others if it is needed. They also have sought similar clarifications.
After 90 days. That letter of the document is released. Yeah. Coordination.
What is interesting is, my lord, same day, two
90
letters.
days.
One letter says that I'm discussing with commercial terms with EM and contractors. So kindly amend your tender conditions. Is very clear. One more letter the same day. And what is important, even on page 359 at 360, your lordship may say what
He
is
has sent it same day.
same day.
It's not that some afterthought or something like that. Same day, two letters he has sent it.
Two independent contradictory stand is what is sought to be taken, saying that kindly amend your term tender conditions to saying that JV, don't include a JV partner. I won't repeat, my lords, whereas whatever is stated. And page 360 may be kindly seen, my lords. What he says at 5 Roman 1, that is at
Clause 17.
clause 17, a timeline. Your lordship, a timeline of 18 days for the preparation of submission of techno-commercial bid has been proposed. However, it is crucial to acknowledge that the extensive nature of the project and magnitude particularly undertaken on an EPC turnkey basis. Preparation of techno-commercial bid would at very least entail comprehensive efforts, so and so, site, so and so, I'll skip all that, my lord.
Minimum 3-4 months, he says.
3-4, then Roman 3 may be kindly seen, my lord. Coordination with E&M and HM contractors and soliciting their feedback for the design of civil components, which can be estimated at least for 90 days. So to negotiate with E&M, he needs 90 days. So out of 120 days, he needs to negotiate with them 90 days. We can't, because there are three people, we can't, public interest is involved, not private interest, my lords. So therefore, he cannot say, I want 90 days, till like, and he wants to change the commercial terms of the tender.
Whether there was a stay before the learned single judge? No stay.
No, stay is my right permitting him to participate. That's the only stay which was there, as well as I should answer all
the
his
opening was there, my lord.
Yes,
Stay of the opening of the bid was there.
Yes, that opening was there. That is what your lordship said at the time of granting the interim order in this appeal. If the stay was there, he is entitled for continuing the stay at the time of admission.
That's right. I had the benefit of a stay.
I'm not denying that. There's no problem. What is there is there.
He extended it because the judgment was not out.
Or
But now
Your
it
Lord,
is it over?
467 may be kindly seen, my lords.
467.
Volume 3.
Volume 3, the same volume. Same volume. This is from. This is the communication, my lord, 467 from GE, my lord, to L&T. That is last, after the Rome, serial number 5.
GE standard time.
Please, who's one of the contractors, my lord? Qualified E&M contractors. Last, after 5. Further, we noted the query raised by L&T during the aforesaid pre-bid meeting, where L&T inquired whether KPCL shall allow E&M bidders to submit multiple E&M MOU with different E&M manufacturers so that L&T can select their E&M manufacturer later after award, which is in fact directly contradicts L&T's proposal to GE to work on exclusive basis for Sharavati. So, my lord, your lordship may kindly see they are negotiating, discussing commercial terms. Till the whole point is, my lord, they wanted to take a pound of flesh from their E&M contractors. So they were trying to negotiate with all of them, saying that after I succeed in the award, I'll take your product. That is E&M which is required under the tender. They say we will not do it. In fact, my lords, if they said you come as a joint venture, they would have got a joint venture partner. Page 466 may be kindly seen that this is regarding G. Even Voigt, they give the same proposal. Page 466. We would like to explore, my lords, fourth paragraph. Page
Possibility to collaboration.
With Voigt as an MOU partner, which client has allowed for so and so, if we get favorable response. So therefore, my lord, the whole game plan of L&T was there will be a successful bidder as a civil contractor. The KPCA should amend the tender documents to suit their needs, saying that let the E&M contractor come later. They were negotiating for that. And they wanted 90 days to negotiate and close that. That is why they were very clear of 3rd of May. That is the significance of that is very important.
Voigt says they are not clear on MOU because the same is for missing from tender. So Voigt did not want to negotiate.
Can I request 465 also, Melos, for a moment, Melos? This is a reply, this is a communication by Voigt. We would like to inform that we are still not clear on the MOU route, as the MOU form is missing from the tender document. Once the MOU format is issued by the customer, we will review and revert on participation via MOU route. However, this is subject to pre-alignment, signing of subcontract agreement, so and so, so and so. So this is on 17th, I'm grateful to 17th February 2024. And the previous letter is 16th.
16th February.
16th, my lord, all this is, my lord, personal interest, D-Horse, all this argument, my lord, is a sham. Here is a case where they want to amend the contract, and he is very well aware there are only 3 E&M contractors, Voigt, GE, and Andrix. He is negotiating with all 3 simultaneously as an MOU or on a purchase of this after the tender. Well, this is nothing but abuse of process, my lords. That is why we made a submission saying that you come, please come and participate. You bring your joint venture, come. Whatever clarification you want, we will give you a clarification. In fact, my lords, after the communication dated 27th March, where we made say that they had certain clarifications are not given, we gave them, they gave around 200, how many questions? Around 52 questions they asked us. Immediately we clarified all those 52 questions. In spite of that, they don't participate, my lords. It is impossible to, we can't file the tender, my lords. This is all clear case where they did not have an E&M contractor. They were negotiating. They wanted to change the tender conditions itself. Now, taking one advantage is we have reduced it from 30 to 21 days. That was the whole game plan.
So all said and done, what is your stand about Rule 17?
In fact, I'll be able to substantiate that also, my lords.
They are saying that Rule 17 is mandatory. You are trying to interpret it as a non-mandatory.
No,
or directory. But if it is to be directory, then the reasons should be.
I'll come to the 17.2.
Where are those reasons?
On page, that is that page, reasons are there, my lord. That is at page number 520, my lord.
So your stand is that you have deviated from Rule 17?
No. Yeah. We have complied with Rule 17.2.
Which gives power to reduce that.
Reasons.
Absolutely.
Let us see. That is what we want.
520, my lords.
520.
Yes. That is at volume number 3.
Yes.
Page 520, Manoj.
520.
520, Manoj. Discussed with FD and TD, Technical Department and Finance. The state is facing severe power crisis this year. Government has been procuring power from all sources and has also issued notification under Section 11 to ensure power produced in the state accrues to the state. To achieve self-sufficiency in power for an RE-rich state of Karnataka, we would kickstart this pumped hydro project at the earliest. The board has noted earlier on 20th October 2023 that this plant was chalked out more than 5 years back, which could not be pursued thereafter for various reasons, including delay in preparation of technical report and DPR and delay in getting requisite clearance. Considering the necessity and the importance of the project and the expedited implementation, the board has on 1/2/2024 has approved for calling a short-term tender for 21 days. Hence, para 34 is proposal is approved. That your lordships will get it at 570.
This is an insertion according to us.
This is
This page,
whose note it is? Discussion with FD and TD. Who
MD,
discussed?
MD, my lord.
MD.
MD, his signature is there, my lord. Your lordship may kindly see page 519, serial number 41. Please discuss Director Technical Financial both. Page 519, right at the bottom, 41. Please discuss MD has written, my lords. But five. Illa, sir, board meeting is. Board meeting is at page 127, 527 at 531.
It can't be an insertion.
10.6. The lordships will got 531, my lords. So this is date of first.
MD note is 41.
Please.
Please discuss.
Please. my lord.
Then discussion should have been 42.
No, next page, my lord.
Huh?
Next page, my lord. That is why they cross the page and then it is typed and this is the discussion, discussed with FD and technical department.
This is an insertion is what we had pleaded, nothing is considered.
My lord, this is not
41
there in the.
and
this
42
is-
next page.
This is not argued, not in the rejoinder.
Sorry,
In appeal, it has come.
I did argue, I am there, I was there, I am Lord, I am making a solemn statement that I did argue saying that this is an insertion.
No,
Is any ground is taken up?
No, not in the
Let us
appeal.
see. They should answer.
Oh, sorry, my
Whether-
apology. I'm
This
sorry,
was
I'm
filed,
sorry.
my lord, at the time of the reply. My lord, what happened was I completed the argument. He completed the argument. After my reply, my lord, he submitted the reply and produced it. At that time, I did specifically say that
They
this
filed
is
a rejoinder to it.
This was filed. After that, you have filed the rejoinder also.
Correct. Correct.
Mr. Holla.
One
you
minute.
have filed a rejoinder subsequently.
Just take that out. I'll just. Because this argument I did make. I remember.
Maybe
That's all right. My lord,
we don't doubt you nor him.
No.
But point is whether such a contention, it's a very serious thing.
Yes.
It cannot be by argument at the bar. It should be based upon pleadings only.
Absolutely.
So
Let me
where
see,
have you
let
taken
me-
up that
let me just see,
contention?
my lord. Let me see, my lord. Let me not waste your lord's time.
That's
Let him
fine,
complete
that's
and then my lord, come back.
This is the arguments that they argued, sir, page 30.
What is this? This is a written submission. Can you request, my lords, the
Which document is disputed? Page 520.
Page 52.
520, my lords.
20.
That is part of which.
Fabricated in the sense subsequently. Subsequently.
Please, ma'am, that is part of our statement of objection.
That's a part of our.
That is part of our statement of objections, my lords.
To which he has filed the rejoinder.
Yes. 620.
Rejoinder, just Mr. Holla, for a minute, just ask your instructing counsel.
Lord,
Whether
we have-
such a contention is taken up.
My lord,
My lord, one
contention
other
is
submission.
612. What we have said is, my lord, let me point out, my lord. Let me read it aloud. Your lords may not even turn the pages. Office note and the board resolution produced at annexure R to rely to the reply, bear out violations the respondent number, violation by respondent of rule 17 of the KTPP rules. It is apparent that these documents are discrepant, unreliable, show that rule 17 of the rules have not been complied with, apart from clearly demonstrating malafide is at play. These documents bear out that there is no urgency, etc., etc.
No, what does it mean? Did you say it is a subsequent insertion? Not like that.
My lord,
Not
if
like
it is
that.
not there, I can't say, my lord,
That's
it
fine,
is there.
that's fine, that's fine.
Just see again, look at it.
And your lordship may kindly, that
But
is
I
not.
had
only
argued,
noted-
but my
Fair
lord,
enough, fair
it
enough.
may not have been pleaded, my lord. Let me, my lord, see if it is there, I'll tell, otherwise, my lord, it's not there is what I'll have.
Not only not pleaded, my lord.
Ground raised in writ appeal.
Even
No,
in writ
no,
appeal, you
no,
have
no,
not taken
no,
up that
no.
contention.
It is raised in the writ appeal.
Writ appeal.
Yes.
Yes, sir.
I'll point out.
I'm sorry, it's taken, I'm sorry.
It is taken.
It's taken, it's taken.
You should, it was Oscar Wilde who said, I can resist everything except temptation.
No, one other page additional, I'm stand
These are
corrected, my
matters
apologies,
of-
my lord, I stand corrected.
These
I
are
should-
matters of record. So from record we will ascertain.
Please, I'm sorry, my lord, I should have. Your Lordship, may kindly turn to amendment application, page 32, my lord. What is it? This is
So this is the key points, the submission.
amendment. 32, my lord.
Page 32,
32, my lord.
first volume.
No, amendment application, that is the
Amendment
last.
application.
It's a separate document.
Separate document.
ಅಲ್ಲಿದೆ.
The March 2024 amendment ಅಂತ.
ಇಲ್ಲಿ,
Rate appeal
ಇಲ್ಲಿ,
ಅಲ್ಲಿ.
ಇಲ್ಲಿ.
Rate appeal ಅಲ್ಲಿ.
Lord, 32 must be 842 because.
Correct, correct.
ನಾನು ಕೊಟ್ಟಿಲ್ಲ sir. Sorry sir. ಇಲ್ಲ ಇಲ್ಲ ಇಲ್ಲ. Sir,
No, it's there, it's there.
Page 842, my lord. The Lordship may kindly see, this is the submission of the petitioners before the learned single judge, my lord, which is filed in writing by them. Not only they have made the submission, in reply submission also is that, is also given, my lord. So therefore, my lord, the argument of insertion was never taken before, I mean, in writing before the single judge.
In what way learned single judge dealt with this?
Please.
Learned single judge dealt with in what way? This rule 17.
Not dealt at all.
Not dealt,
Not dealt.
Not dealt.
not dealt.
On the ground that he didn't, they
Not
did not
taken.
participate.
Yes.
Please.
No, sir, it's dealt, sir.
No.
Rule 17 is dealt.
No, I'm sorry, my lord. The That's page
No,
volume
Mr.
4.
In all fairness, Mr. Valla has read out that particular.
That's all. That is all.
That's all that there is.
Correct.
So therefore, my lord, insofar insertion at page 520 is neither pleaded in the objection or in the written submissions filed before the single judge. Written submission, which I just pointed at page 6. See that page?
Written submission is.
Is there a page number?
So 8, sir, written submission page number.
What is the page number?
844.
844.
844, in the written submission also this, so therefore to say it has been inserted now in writ appeal, my lord,
Is not acceptable.
acceptable.
Where does it say? You have inserted. No, then we know what else is.
So according to you, rule 17 is complied.
Rule 17 is complied.
Complied with.
Rule 17(2) is complied. Not only rule 17(2), rule 17(1), 30 days also has been given. He refuses to participate. He's negotiating with commercial with 3 bidders. And he wants us to change the whole tender conditions to suit him so that he can have a better commercial terms. This is a public interest project which we are interested in the state shortage of power as against a person who can make maximum money by negotiating with the 3 E&M contractors.
The only statement which is made.
And the argument of Malafites is that they should to exclude him. So that argument falls in view of the submission made before the single judge, come and participate. Is the argument of Malafites, even though it is not raised or pleaded, to show this. Because one of the principles judgments which are said wide publicity should be given, maximum number of people should come. Petitioner himself is not ready to come, my lord, saying that I want only argument, it should be postponed. His argument says you should not go ahead with the tender. I will not participate.
Sir, just page number 38 only. He's not said inserted. He said it's been tampered with.
We want to ask you one more question.
Please.
It is not that the project is conceived of immediately.
Absolutely.
Years were there, where your employees, your people.
Lot of people are sleeping over
Lot of preparation has been done. Why that tearing hurry?
To who? According to who?
30 days. No, even just because
I
that
understand.
argument is done. What heavens would have fallen down if it were to be 30 days, 40 days, 45 days, 90 days? What heavens would have fallen down? For two reasons. The project is not, say, 50 lakhs, 2 crore, etc. It is about 2 crore. Matter does not end there. It is 8,000 plus crores. For any entity to decide whether I should be in the fray or not, several preparatory steps are to be taken. And your clearance applications, according to you, which were made, according to him, that were not made also, will go according to your version. Decision was not taken by the government, central government on them. They were still in the process. At least 2 documents are like that. How a person like appellant or of that class will be in a position to make a rational decision? Yes, I can participate in this tender process.
If the petitioner's argument is to be accepted, Manoj, it will take another 9 years, Manoj.
Why?
I'll tell you why, Manoj. All what he has raised in the writ petition are to be done post-tender. Only with the, he's taking a contract document, not the tender document. These requirements are of a contract document with a successful bidder. The tenderer need not fulfill these conditions. He is saying, I will fulfill the condition with the once what is not to be required also. He cannot say that give me 90 days or 120 days to comply with conditions which are part of the contract document but not of the tender document. We replied saying it's not required, you participate. No, he said, no, I will comply, then only you do it. Well, your Lordship may kindly see his approach, my lords. In fact, we have replied, in fact, I made a short note on why none of it is required as per the 10 court officer.
Take that.
Yes, sir. Yes, sir.
1 minute, please. Your note.
No, none of them, I pointed the contract document and tender document. These are all issues. Therefore, my lord, these are issues to be raised when a person is not interested to participate, wants only time to negotiate with this commercial terms, he finds loopholes. Why, on what ground I cannot, why I should not participate in this tender and postpone the tender?
Excuse me.
Yes, what no, what is one other side. I will not start before this. It's like a dog in the major policy, man. It can't. And ultimately, what is his right to say? Ultimately, what boils down to is, can a tenderer say postpone the tender to a particular date or time, or I'll put it after 90 days? Can he ask for what reason? So therefore, my lord, submission on so far as these are concerned, my lord, your lordship may kindly turn to 1.1 serial number 1, my lord. His first contention is the contention of petition 120. Site survey and investigation is covered under section 2 of the tender document at page so and so. This work is to be done before starting detailed engineering work. See clause so and so. So KPCL hands over all basic survey grids and benchmarks prior to the contractor commencing the work. So it is to be done by us. Him saying that I'll do the survey question does not arise. It is subsequent to, this is part of the award of contract. So him saying, I have to go to the site, I have to verify, all that does not arise. We give him the document. Next is, my lords, basic reference design. That is also given by us as per clause 5.3, volume 2. Then, my lords, seeking opinion from design which is already available. Then, my lords, with regard to appellants as a similar tenders 100 days, he has not produced any document of similar work. In fact, we have denied that aspect also, my lords. What?
Any prescription is there, experience, he should have done work of that nature.
Yes, all that, the basic requirement, my lords.
He does not have.
He, as a civil contractor, he has. Not as
himself.
Not by himself, he's not, that is my respect. By himself, he's not eligible to participate.
But your tender prescription is not that he himself should have that.
No, that is why I say, that is not. He can bring in a JV partner and then do it. But what he's doing with the JV partner is, you don't come as a JV partner, you come as a under a MOU supplier. L&T's GE says, no, I don't want to participate as
it can't be done post-award.
Post-award also. So therefore, Manoj, this is, basically, that's why he gives 2 letters. One is give me 120 days, 90 days for negotiation. Here he says that change the tender condition, both on 5th March. Therefore, Manoj, the question is, I would understand if 21 days is given only to the petitioner, I give 90 days to the other bidders. So 21 days is uniform for all bidders. There's no arbitrariness in pick and choose. What could have been found out about this discrimination insofar as period to each bidder? And one other thing, my lords, it is not the case of the petitioner that it is malified or malicious. That is not a ground of challenge for 21 days. Insufficiency cannot be a ground of challenge. Ground for setting aside a tender condition would be arbitrary, malified. Is this case is insufficiency? It's not a case of malified or case.
Insufficiency of period.
Period.
That is what they're saying, arbitrary.
No, for him, not for all the other tenders. So therefore, when every out of 4, 3 tenders could have participated.
But even they had sought for extension.
So we gave them 2 days, they were happy sufficient. 2 days they were said.
On what rationale you have given extension?
After discussing with them, in presence of them, we gave 2 days. Because your Lordship saw that everybody, the proceedings which was pointed out at page number, volume 3.
Those 3 entities.
Yes. Please, that chart, that. In fact, I would show me the information.
Yes, sir. For amendment, sir. You just click on. Sorry, just give me 1 minute, sir. I'll find it.
It is not 10.
Nice. 10.
Amendment.
855.
Yes, I have to respond. Yes,
I'll just read the judgment quickly, Manoj. The learned single judge, Your Lordship, para 10, Manoj, it's part of the amendment application. The petitioner claimed to the company under the Companies Act is a reputed
may not be necessary because we have read that judgment.
Okay, I leave it at
We
that.
come after reading
I
almost
understand.
every page and every word in the impugned judgment we read.
Therefore,
We
Manoj,
have no other job than reading.
My lord, I would say that if you had given any other job also, your lordship would know only this job. So once a judge, always a judge, my lord. Even that habit dies hard. Therefore, my lords, my respectful submission is, my lord, this is not a case where this court should interfere in extending a time in the facts and circumstances of this case, my lords, where there no arbitrariness pointed out by the petitioner, except for showing that he wanted time to negotiate with the E&M contractors.
Said in the facts and circumstances. Did not the abstract principle also?
No, what, for example, my lords,
Are you arguing that in abstract?
not in an abstract, what I'm trying to say is, in a case, given case, my lords, assuming for a moment.
There can be an abstract proposition also.
No, not,
Why
I
not?
stand corrected, my lord. What I meant.
Why
was-
not?
What I'm not arguing for the next case which is coming.
Can't extend the time for
Okay,
submitting a bid.
I stand corrected, my lord.
By way of abstract proposition, the court can't extend the time for submitting
That's all, that's.
abstract,
In fact, I would like to give the-
uncontextual of
that's all.
facts.
In fact, I would just
It
like to
can be,
give
it can be a pure proposition of law also. Why don't you argue that?
yes,
will
well,
not accept.
just, these judgments have, Your Lordship kindly permit me to place these few judgments on. My lords, I fully bow down to your lordships, my lords.
I don't think so, my lord. Even as an abstract proposition of law, my lord, I would say a court in exercise of its power under 226 cannot extend time. But the court is not sitting as an appellate court.
So we are taking tips from what we observe.
No, what left, what fell from your lordships, my lord?
We only
It's a
think, we don't-
technical.
We are only thinking, we are not observing.
No, that's why we adopt what your lordship observed as our submission.
So Monday.
The lordship may kindly. The lordship may kindly, I'll just read the scope of interference in judicial matter and tender matter. Fixation of bid submission time falls within the commercial prerogative of the KPCL.
Where is that?
Your lordship may.
It Michigan,
Please,
not
my lord.
not Michigan rubber.
That is also there, my lord. That is at serial number, page 33, my lord.
Page 33. Michigan.
Page 46.
Page 46, para 23, my lord.
Sir, I'll find it.
In fact,
sir. I'll find it, sir.
From the above discussion, the following principles emerge. The basic requirement of Article 14 is fairness in action by the state, and non-arbitrariness in the essence and substance is the heartbeat of fair play. Michigan rubber. These actions are amenable to judicial review only to the extent the state must act validly and discriminatory reasons and not whimsically for ulterior purpose. If the state acts within the bounds of reasonableness, it would be legitimate to take into consideration the national priorities. Fixation of value of the tender is entirely within the purview of the executive, and the courts have hardly any role to play in this process except for striking down such action of the executive as this proved to be arbitrary or unreasonable. If the government acts in conformity with certain healthy standards and norms, such as awarding of contract by inviting tenders, in those circumstances, interference by the court is very limited. See, in the matter of formulating conditions of a tender document and awarding of contract, greater latitude is required to be conceded to the state authorities unless the action of the tendering authority is found to be malicious or misuse of its statutory power. Interference by courts is not warranted. Certain preconditions, I'll skip that, Manoj. If the state or intermediary acts reasonably, fairly, and in public interest in awarding the tender contract, here again interference by the court. This is the sum and substance.
Ronak International.
Then, my lord, in infrastructure projects, the interference by the court should be very limited, my lord. That is at page 164, my lord. Where did it go? Page 164, my lord. That is Ronak International, my lord. That is Roman number 5, principle, page 156.
See, 164.
Page 164, para 9. The judgment starts at page number 156.
Ronak International.
Please, my lord. Para 9, can I request, my lords?
There are 9.
Para 9 of the judgment, running page 164.
Interference is restrictive.
Please, I'll just read this one paragraph, my lords. The award of contract which is by a private party or by a public body or state is essentially a commercial transaction. In arriving at a commercial decision, consideration which are paramount importance are commercial consideration. There would be the price that the other side is willing to work, whether the goods or service offered are requisition, so and so, so and so, so and so. Even when the state or public body enters into commercial transaction, consideration would prevail in its decision to award the contract to a given party would be the same. However, because the state or a public body or agency of the state enters into a contract, there could be in a given case an element of public law or public interest involved even in such commercial transaction. Where what are these elements of private? This is important, man. What are these elements of public interest? Public money would be expended for the purpose of the contract. Goods or services which are being commissioned could be for public purpose, such as construction of roads, public building, power plants. This is power or public utility. The public would be directly interested in timely fulfillment of this contract. This is very important, Manoj. Public purpose contract, so as the service becomes available to the public expeditiously. The public would be also interested in the quality of work undertaken or goods supplied by the tenderer, poor quality of so and so, so and so. So therefore, Manoj, while addressing what are the elements of public interest, timely fulfillment of this is also very important, Manoj. And next, Manoj, para 11, for public good and interest, poor quality of work can lead to tremendous so and so, so and so, so and so. Outlay either the corrected mistake in rectifying defects or even in redoing the entire work, thus involving larger outlays of public money and delaying the availability of service, facility or goods. Example, a delay in commissioning a power project as in the present case. In the present case means I say in this case also, my lords, could lead to power shortage, retardation of industrial development, hardship to general public, and substantial cost escalation. When a writ petition is filed in the High Court challenging the award of contract by public authority or the state, the court must be satisfied that there is some element of public interest involved in entertaining such a petition. If, for example, the dispute is purely between two tenderers, the court must be very careful to see if there is any element of public interest involved in the litigation. Mere difference in the price offered by two of the tenderers may or may not be decisive in deciding whether
that may not be. We will not travel to that at all.
Then next sentence, my lords. It is important to bear in mind that by the court's intervention, proposed project may be considerably delayed, thus escalating the cost far more than saving, in which the court would ultimately affect in public money by deciding the dispute in favor of one tenderer or other. Therefore, unless the court is satisfied that the substantial amount of public interest or satisfaction is entered into malified, the court should not intervene under section 226.
Go to 21.
21, please, madam. The Lordship's reading is far. It is unfortunate that despite repeated observation of this court in a number of cases, such petitions are being readily entertained by the High Court without weighing the consequences. In the case of so and so, so and so. So, Tata Cellular, they refer to all the judges.
What he's saying is, even government acts fairly, even.
It is so and so, so and so. The government acts fairly through falters in the wisdom. The court should not interfere. The court observed a pragmatic approach to social justice compels us to interpret constitutional provisions, including those like Article 32, 226, with a view to see that effective policy and the policing of the corridors of power is carried out by the court until another ombudsman arrangement emerges. The court cannot usurp or abdicate and the parameters of judicial review must be clearly defined and never exceeded. If the directorate of
court should not undertake a deeper examination.
Especially
These facts appear to be the inner voice of the judgments.
Infrastructure project, power project, referring to, and this is also a case of power project. So therefore, my lords, court should be slow in entertaining. And next proposition, tender conditions should not be cannot be challenged. That is the second proposition in the compilation had been given. third proposition is, my lord, the reasons need to be elaborate, but has
Need not
to-
be.
need should be, need not be elaborate, my lord. Need not be elaborate, but there has to be application of mind to reduce the minimum period. That is 17(2), my lord. And fourth proposition, respondents having chosen to,
Justice Arvind Kumar's judgment.
please, my lord. Respondents having chosen away to stay away from the tender cannot be permitted to challenge the tender. My lords, here, my lords, I understand if you had participated the tender, submitted the tender, and then said, see, I am not able to comply with this because I need.
No, then you would have said you are stopped from coming, challenging.
No, it's only a question of extension of time, not estoppel is here. What is the only case is, my lords, is at least projected before the court is, I need more time to submit my bid.
Any caution money pre-deposit is stipulated in the tender, even for bidding.
This bank guarantee, my lords.
What is the amount?
That is around, that is there, my lords. I'll just, around 10 crores that has been refunded, cancelled and refunded. Just-
And forfeiture clause also.
Yes, my lord.
Then how can you expect him to
I'll just tell the
bid
amount.
and then
my lord.
come to the court?
80 crores.
80 crores, my lords. Two bidders have given 80 crores each. No, what is that? General question. They had all the three bidders are quoted, given EMD of 80 crores. Two of them we have refunded on immediately, my lords. And bank guarantee also has been given by the successful bidder, my lords. It's written in the note I'm saying.
Anything to be added by Mr. Raghavan?
Monday.
Monday we can.
Not
So
sitting
that
in the second half.
Mr. Valla also has to reply. no?
We'll start at 11 itself,
Okay.
10:30 itself,
Please.
10:30.
immediately, so that.
Yes, ma'am.
Once
Only
for
thing,
all.
I'll come online, my lords, because I finished my arguments, I'll be available. Because I'm not in station.
Already you take all the whatever you know.
We ask the questions, we will not answer. All right.
Whatever you know you want to take from here, take it.
Yes,
Extended.
yes, anybody? Yes, madam.
Interim order has to be extended, my lord, in our case.
It will be extended.
That's it.
Stand out to 23rd, 22nd. Interim will, if already operating, shall continue to operate till the next date.
That 57, the very registration of IBC case is struck down by the learned single judge. Twice the matter was listed.
Now after.
The reason is, my lord, the arbitration proceedings are going on day-to-day basis. The very registration of the insolvency proceedings are struck down. It was not even referred to the resolution professional for a report.
But then.
Monday or Tuesday. ma'am.
Serial number 9, it is medical admission matter, my lords, where the students have not reported the students down to management. Subsequently, even after the allotment, counseling. Therefore, my lords, the matter is little urgent, my lords, therefore it may be.
No, there was no urgency, no, other day.
No, it is not that matter, my lords. My lords have given today's date. Because of urgency, it may be taken up on Monday, my lords.
Request for Tuesday, my lord, some inconvenience.
What is your matter?
My lords,
What is your matter?
serial number 9, my lords.
Which one?
What's the urgency?
Urgency is, my lords, these all students were relocated pursuant to NMC order and also on the order of this honorable court. And those out of 150 students, all 120 have been allotted and they have been admitted, they are attending the classes. Whereas for the second year MBBS and 30 students belonging to management quota have not been given because of the DME's order that they have to take the fee which was notified by the errant college, that is 6th respondent, to the KEA. Therefore, my lords, these students are not even attending classes.
This can
No
be,
admission.
This can be dealt with after vacation.
No, my lords, that is the urgency is because others are attending classes. They have already given one internals. These students are now stuck, my lords. They are not even attending classes.
23rd.
My lords, it may be on Monday, my lords, please.
All like Monday.
Please, my lords.
Serial
Obliged.
Slight inconvenience.
Serial number 19.
19.
19, my lord. It's extensively heard. It's a matter of VTU nomination of executive council members, my lord. Matter.
Everywhere it is instant.
As the architect of the whole
After.
Lord, serial number 2, my lord, is a
But your art of construction is here.
That's that matter.
You might be not using, but still. But that
serial
is
number
not
2,
the-
my lord.
That is only your excuse not to take up because no time. After
Will also leave.
after.
My lord, one request.
Is that your file, sir? No, I think it's Vivek's file. Vivek's file.
Mr. Mahendra, what is to be done? Case cutting.
Yes, we have reduced year and in which it clearly shows.
Immediately we'll keep it first week of reopening. 29th May. 29th, right?
My lord,
Now it means the government has also passed an order to take over the palace where they are paid TDL based on the direction of the it is submitted by Tuesday or Wednesday. The government order.
No,
there is no urgency, my lord. It may be called after.
After vacation.
Serial number 2, my lord, Monday, my lord, it's a contempt matter. Your lordship have already heard this matter.
Yes, Monday, yes, but 27th May.
serial number 28.
No, not this.
My lord, one request in serial number 19, my lord, since the matter has been heard extensively, the matter may be
Any
treated
of
as
the
part
memo of
of.
withdrawal dated 13/3/24. The writ appeal is pursuant to be withdrawn as prayed for, dispose of accordingly.
My lord,
Memo of
Lord, one
memo of
request in
withdrawal to be
19.
quoted.
my lord, one request in 9. My lord, one request in 19, my lord, since the matter has been heard extensively, it may be treated as part heard.
Which matter?
VTU matter.
Partition. Super partition.
Yes, sir. This is another matter. So same matter connected, it's not connected with those matters. No. Fresh matter, separate matter to be called.
This is a separate matter.
It is to be heard.
Heard along.
Serial number, your lordship's kindly.
My lord, serial number 12.
Now we're handing over to court office.
With your lordship.
Since 1 year,